think you need to resolve this case?
So I anticipate, obviously I need to review the amended information. Based upon the deposition, there is going to be a motion to dismiss on at least 2 counts. So I don't think that we're going to be ready for a trial probably until the summertime. So as soon as I get to review it, then I can start working on the motion. So probably 2 continuances would be able to get us to allow us to get all the work done and then get ready for trial if that's what we need to do.
What needs to happen other than reviewing the amended information for you to file the motion?
I don't know if it's going to require another deposition, but essentially, in doing the first deposition, the information was so bare that required the motion for statement of particulars. Based upon that, I really don't know. I haven't looked at the amended information.
All right, I will grant a final continuance to June 8th at 9 o'clock. So whatever motion you need to file, please get it filed soon so it can be heard before then. Do I need to set a time frame?
I don't think so.
Okay. What I'm trying to avoid is the motion getting filed right before the next court date, and then we can't get it heard, and then that's going to be a basis for another request for continuance. The case is a year old, the new law, a year old, and it's been continued 4 times. I understand that you had to file the motion for statement of particulars, and you filed it promptly after our last court date, and then the amended information was just filed today. I understand all that. So I'm just trying to make sure that we stay on track.
I get that, Judge. I can tell you this based upon my reading, our reading of the statute, and based upon how the information came out at deposition, that this is definitely a more technical motion that we'll be filing, so it's going to take a little bit more research and a little bit more time. It's not just a simple motion to suppress or dismiss.
Okay.
So we'll work diligently to get that done. Unfortunately, this isn't my only case.
Okay. Well, let's see where we are, and if you do get that motion filed, please request a hearing right away.
Yes, ma'am.
Okay. So is your motion for statement of particulars now moot? We don't know?
It depends on what the information shows.
I suspect so. Certainly, Ms. Basso's indicated that indicated to me that the original information was deficient, and so if there are any other issues relating to a deficiency that we see on the amended information, to reach out to her, and she would make those requisite changes.
Okay. Well, if you determine that your motion for statement of particulars is moot, just file something so that the record is clear that that motion's been disposed of or no longer needed, or...
Yes, ma'am.
Okay, resolved. All right. So Mr. Hartzog's, both of his cases will be June 8th at 9, which is anticipated to be the last continuance. But I understand if there are unforeseen issues like need for another deposition, and you present good cause.
Thank you, Judge.
Thank you.
Finally, Jay Patel and Tim Shaw on behalf of Christopher Emmanuel Davis, if Mr. Shaw, Ms. Herndon, and I can approach.
Yes, let me read out the case numbers really quickly. Those are 22 CF 2402, 24 CF 926, and 24 CF 1162. Did I get them all?
Correct.
Yes.
Okay. All right. Come on up. All right, this will be the final continuance in Mr. Davis in his 3 cases. That would be June 8th, 9 o'clock. And the state needs to pick one to try.
I have nothing further before the court. I believe Mr. Shaw has other cases. May I be excused?
Yes, thank you.
I'll just wait for my name.
Okay, thank you, Mr. Shaw. Mr. Dyer?
Thank you, Judge. Good morning.
Good morning.
Your Honor, the first case I have on the docket, I believe is Mr. Hockmeyer, 25 CF 865. There's a waiver on file. Judge, if we can set Mr. Hockmeyer for docket day, I believe it will be a plea. I know the court indicated this would be the last time up.
Yes, and let's see, I have Mr. Ferris for the state, is that right?
Yes, Your Honor.
All right, 25 CF 865, yes, I do have it down. This case is a year old, so this would be the final cycle. We're
Correct,
gonna
Judge.
resolve it this time, so.
Plea or trial for docket day?
Plea or trial,
Thank you, Your Honor.
and that would be April 20th at 9 o'clock for docket day. That'll be the last day I accept a negotiated plea.
Understood.
All right,
Next one, last name is Butturini, 25 CF 1900. Judge, a depot is set on May 11th. If we can put that case on 6/8.
just one second. All right, so you have a deposition scheduled for May 11th?
May 11th, and I will get that notice filed this week, Judge.
Okay. And I believe this is Ms. Gaynor's case.
Yeah, that is Ms. Gaynor's case. There was no objection.
There she is.
No objection, Your Honor. The
Miss-
state is ready, but I do see that depots are set in May.
Okay, so this will be the final continuance. This case is from September,
Understood.
so this is the last one, and that'll be June 8th at 9 o'clock.
The next case is Mr. Hasker in 25 CF 2293. There is some additional evidence that I'm trying to get, Judge, if I can put Mr. Hasker on 6/8 as well.
All right, what are you needing from the state?
Mr. Hasker is trying to obtain some surveillance footage, and I may need to set depots of the alleged victim in the case, and there were also several witnesses. I've spoken with the state about that. I may try to avoid setting all of those depots if I can get that video that
Okay.
Mr. Hasker is trying to find.
All right, Mr. Ferris?
Yes, Your Honor. There have not been any depots. The state doesn't have any objection to another continuance.
What about this video?
Mr. Hasker is trying to obtain surveillance footage from restaurants on 98, and I think he's inquired with hotels, the Shrimp Basket, AutoZone, so we're waiting to hear back to see if those do exist.
Okay, so it's not something you're waiting on from the state? He's
Not from
trying to
the
get that
state.
independently?
Correct, Your Honor.
Oh, okay.
And the last case I
Oh,
have...
wait, just one second.
Yes, ma'am.
Mr. Hasker, any objection, Mr. Ferris?
No, Your Honor.
All right. June 8th, 9 o'clock, so we need to start wrapping that one up as
Understood,
well.
Your Honor.
All right.
And then the last case I have is FALER Falero, 26 CF 121. Judge, if we can put Ms. Falero on June 8th as well. There are 2 open civil cases. I believe you are assigned to one, maybe a quiet title action, or is it the probate case?
I believe it's a real estate case, and I
Right.
believe
And
it's
this-
been resolved. I just haven't entered the order yet,
With the sale of the home, is that right?
if I remember correctly.
So once the sale of that home is done, I believe that will help resolve this criminal case.
Okay.
because restitution is a big part, and I think there's a solid amount of money to be made once that house is sold.
All right, who
If you-
is, oh, go ahead, sorry.
I believe it's ASA Jardina. I'd ask for 2 cycles, knowing the house needs to be sold, and that could take some time.
Your Honor, we would just request a one cycle continuance.
That's fine, Your Honor.
Stay up to date on this and not let it fall through the cracks.
All right, so I will continue Ms. Ruth Valero's case, 26 CF 121, at the defendant's request to June 8th at 9 o'clock for pretrial conference.
Thank you, Judge. That's all I have.
Thank you.
Have a good day.
You too. Mr. Gilbert?
Morning, Your Honor.
Good morning.
Michael Gilbert on behalf of Cody Hoover in 26 CF 208. We have a waiver on file. We'd like to leave that set soft for docket day for a plea.
All right. And who do I have for the state on this one?
James Ferris, Your Honor.
Oh, great, thank you. We will set Mr. Cody Hoover, 26 CF 208, for April 20th, docket day, 9 o'clock, plea or continue.
Thank you, Your Honor.
Thank
That's all I have.
you. Ms. Merrifield? Good morning.
I'll go ahead and take the cases under Flaherty first.
All right.
The first one, I have Bernie Merrifield on behalf of Mariah Conklin. It's 25 CF 2296. And Judge, we have a plea in absentia to a lesser included, if I may approach.
Yes. Thank you so much. Oh, thank you.
And Judge, in Ms. Conklin's case, she's withdrawing that previously entered not guilty, entering a no contest to a lesser included misdemeanor. Ms. Conklin is going to be supervised through JCS probation. She resides out of state, so I'll be providing her that QR code so she can check in today.
That is wonderful, thank you. And I'm just looking over the agreement, and for Madam Clerk's benefit, it looks like Ms. Conklin is entering a plea to the lesser included offense of possession of drug paraphernalia, which is a first-degree misdemeanor, Florida statute 893.147. The terms are laid out in the agreement, and let me confirm the costs. 288? 270. 270 in court costs. It says on here 288.
Certainly don't object to a lower court cost. Thank you, Judge.
Okay, do you want to, I'm going to let you scratch that out, and
May I approach?
yes, come on up.
Thank you.
If you would just fix that to 270. And then initial it. Thank you. All right. And I am going to sign the agreement. And hand it to Madam Clerk.
Thank you, Judge. The next case I have is Brian Cunningham, 25 CF 2479. I'd like to leave this one set for docket day without. We also have an agreement. I had anticipated turning it in today. However, I do need fingerprints, and those won't arrive until a little later on this afternoon. So if we could set him for 4:20, his case will get resolved.
All right, so that would be April 20th
Yes, ma'am.
at 9 o'clock for a hopeful plea.
Then the next case I have is Nicole Fife in 25 CF 2434, waiver on file. We did complete our depositions and were able to come to a resolution. I'd also like to set her for docket day. I anticipate a resolution on that day.
All right, April 20th, 9 o'clock, hopeful plea.
And the last case I have, Judge, is under my name. It's Tyler Auten, 25 CF 1004. There's a waiver.
All right,
We have completed everything that is necessary in this case. I met with ASA Basel last week and discussed a resolution. I just need a little bit of time to bring Mr. Auten and his family in to discuss that, so I'm requesting the 6/8 pretrial. However, if we can come to an agreement, I can move that one up on the docket.
all right.
Ma'am, there's no objection. We understand that it may need a little extra time to explain it to our client.
Okay. So June 8th, 9 o'clock, pretrial conference, that would be the final continuance.
Yes, ma'am.
All right.
And that should be all I have. All right, I'm getting the go-ahead. Thank you, Judge.
Thank you. Mr. Cobb?
Good morning, Judge.
Good morning.
The first case I have on your docket is State of Florida versus Ms. Foreman, 25 CF 1655.
All right.
We had depositions in the case. I'm in the process of getting them transcribed. During the course of the depositions, a couple witnesses had problems with the link. I may need to redepose them, I'm not sure, but I've discussed the continuance with the state. They have no objection. I am asking for one additional continuance to June, and the cases will be resolved, or be ready to be resolved by then.
Any objection?
No, Your Honor.
All right. Yeah, I have a note. You had 15 depositions in March.
Yes, ma'am.
And everybody showed up?
Most everybody except for the other individuals involved in the fight, so,
Okay.
yes, ma'am.
All right, so this would be the final continuance?
Yes, ma'am.
All right. June 8th, 9 o'clock, pretrial conference for Ronisha Foreman, 25 CF 1655.
Thank you. And then the next case I have, Judge, is State of Florida versus Mr. Goff, 2025 CF 2143. I am asking for a continuance to the June date. I'm trying to get transcripts of a bond hearing that you held back in 2025, and there were issues in the bond hearing surrounding, I guess, what a recording or a record was, and I want to get those. And I'm still trying to see if the former attorney did depositions in the case, and I may have to obtain transcripts of those. But I believe I can get all this resolved by June, and I won't be asking for additional continuances. If I can't resolve it, I'll be asking for a trial.
All right, and Mr. Goff is present. And sir, next time you come to court, please wear long pants. And I will grant the continuance to June 8th, and this will be the last one.
Yes, ma'am.
9 o'clock, pretrial conference, and thank you.
I'll do that in a motion with the state. I'll take care of that. All right, those are the two cases I had, and I'll see you on Wednesday.
Yes, there are a couple of cases on Wednesday's docket that I didn't see a notice of appearance yet.
The
So-
one murder case, I'm still doing a conflict
Okay.
check, and it's a lot of discovery. I'm going through that,
Okay,
and
Just-
I will let you know for sure.
just wanted to make sure you're aware.
I am, yes, ma'am.
Okay, good. Thank you.
All right, thank you, Judge.
Mr. Switek? Good morning.
Good morning, Your Honor. First case I have today, Your Honor, is Danielle D. Giovanni.
All right, that is 2020 CF 1235.
This case, Your Honor, the clerk put it back on last week. There's been no activity for 5 years. It's been sitting dormant.
Yes, I don't know what happened to it. It looks like in May of 2021, the bond was reinstated and a capias was recalled, but it wasn't put back on the docket, and right now I can't remember how I discovered it. I think I was going through a case list of open cases and trying to figure out what's going on, so.
In any regard, I've tried to reach out to Ms. D. Giovanni with the available phone numbers and emails that I have, and I have not been able to get a hold of her.
Okay. So, and who do I have for the state on this one?
James Beresford.
Okay. What do you suggest that we do, Mr. Switek?
Dismiss it.
That is a decision that would need to be made by the state.
I wrongfully filed over the weekend an expiration of speedy trial, and then I realized I hadn't gotten a hold of her and can't get a hold of her. But that does come into play. But we rectified that this morning and withdrew that notice. It might not be on your docket yet, but it's been filed.
Okay. So, attorneys? Are you asking for the June date? What are you asking the court to do?
Well, I guess that would be best. I don't know that if the court would let me withdraw and she would have no representation. But on the other hand, I really have no realistic hope of contacting her.
Okay, looks like she has a bondsman. So, how about reaching out to the bondsman?
We could try that.
Okay, I will make sure that notice of the next court date gets sent. I'm going to set this, rather than let it sit for another 2 months, I am looking at, I can either set it for docket day next Monday, or we have a date in May we could set it for.
Well, let's try May. That gives me a realistic opportunity to see what I can do.
Okay, so we have the afternoon of May 14th. We have the morning of May 14th. We also have morning and afternoon on May 21st, and we have May 19th. So 14th, 19th, and 21st. Which day would you like?
Either the 19th or 21st. The 14th, I'm out of town.
Okay,
19th.
all right, so that would be May 19th at 9 o'clock. And we will call this a case management conference or status or,
Yes, Your Honor.
okay. And could you please notify the bondsman of that date? Thank you. And Mr. Swiatek, good luck.
Thank you.
Hoping that you will be able to locate her, but I understand after a few years it's probably difficult, but the case is just open, it was just sitting there, so.
Next, I've got Devani Essen, 25 CF 1674. Mr. Essen is present. The state and I have come to an agreement to reschedule this for Thursday. There's been a hiccup.
If you're going to put it in on Thursday, then the victims in the case would like to be present. It's not going to be an extended plea, it's agreed upon, but we were asking if maybe we could do it on Thursday, if that's possible.
Yeah, we
Sure.
have a signed plea agreement.
Ms. Basso, I know we have some other hearings in the afternoon on Thursday. Would morning be,
I can be available whenever the court's available.
okay?
Morning is better for me.
Okay, morning of April 16th. That's Thursday.
I'll let them know.
I have a lot scheduled that morning, so, I'll get to it as soon as I can, but I mean, it might not be right at 9 o'clock.
That's fine.
Okay. April 16th, 9 o'clock for a plea. All right.
And that's all I've got today, Judge.
Thank you, Mr. Swiatek. I will see you on Thursday.
Yes, ma'am. Thank you.
Thank you. Mr. Browning? Thank you.
Coy Brandon for Asa Davis, 25 CF 1644.
All right.
Judge, this is going to be a plea to 2 misdemeanors, a written plea agreement. May I approach?
Yes. Thank you. All right, I've received a written plea agreement in Asa Davis, 25 CF 1644. Let me check with the clerk regarding the costs. This agreement says $981, and it looks like, count one will be dismissed, and it's as charged on counts 2 and 3, according to the agreement. $438 and $500 fine. Mr. Browning, I have a calculator up here. I'm trying to work out to make sure the figure of the costs is correct. Madam Clerk tells me it will be $438 cost plus a $500 fine plus a 5% surcharge on the fine. So whatever the math is on that, this agreement says $981, but you're welcome.
Oh, so we're saving money.
Well,
got
whatever
less.
the required court costs are, that's what they'll be, and the
Okay.
fine.
Okay.
And I will sign this agreement. And I'm going to hand it to Madam Clerk, and he needs to, oh, well, let me ask this. Does the state have an announcement on count 1?
Your Honor, the state is dismissing count 1
All right.
in exchange for a adjudication as to a DUI.
All right. He needs to check into probation today, and I'm handing the signed agreement to Madam Clerk.
Your Honor, is a Department of Corrections probation or JCS?
It looks like it's JCS.
Thank you.
Thank you. All right.
Lastly,
Thank you.
Judge, Farouk Hossein is 25 CF 2377.
Yes.
The judge, first round of discovery just came in last week, which includes 20 videos, and we're still missing a couple things. The state's just been made aware of that, so we're asking next pretrial date, Judge.
All right. Any objection?
There's no objection, Your Honor.
All right. And I do have a question on this. First of all, we will continue 25 CF 2377 to June 8th at 9 o'clock. But I do have a question. It looks like there was a CT case, 25 CT 2327, that was merged into this case. There's also a TR case, which is still assigned to county court, which it appears it might be on my Wednesday docket, so I don't think it needs to be.
Can we merge it can we move it to this, merge it with this, Judge?
Let's see, it's 25 TR 010847. And what is the state's position on that?
Your Honor, the state has no objection merging it.
Okay, so we will merge 25 TR 010847 into this case. Does that mean the state has to file an amended information, or how does that work?
No, Your Honor. Your Honor, we really don't have a position on TR cases, as they're not under our control.
Okay.
It's a infraction, so I'm not exactly sure.
We definitely wouldn't file an amended
No.
Okay.
information for sure. We
So-
really can't object or not object because we can't have a position.
So is it merged or just transferred? Or does it remain in county court?
The TR would stay.
Okay.
Well, I would ask the TR, if we could we move it to circuit court so this can all track together, Judge? If we resolve the case, the TR could be addressed if there's going to be a plea. If for some reason the state we're going to try the case, then maybe we could send it back to county court.
Well, what I could do is just leave it where it is, and then if you resolve it, we can resolve it at that time.
Okay.
So we're not going to merge 25 TR 010847, but for some reason that case is on my Wednesday docket, I think. Let me check. And it's assigned to Judge Reed.
Yes, it's been in Judge Reed's court.
Yeah. So, but I think it's on my Wednesday docket. So let me just double check.
But I have Judge Reed Wednesday.
Okay, then maybe it's with him,
Maybe it's on
but
his docket.
I think it's turning up. Let me take a look. Yeah, for some reason, I think it's turning up on mine.
It is tracking on Wednesday, just the 2 cases.
Okay, on my docket? Okay, it really needs to be, it's assigned to Judge Reed, so can we? Thank you. It's going to be with Judge Reed,
Okay.
so it's not going to be on my docket on Wednesday.
Understood.
All right.
All right, that's all I have, Judge. Thank you, ma'am.
Thank you very
Yes, ma'am.
much.
All right.
Mr. Flowers?
Judge, I'm going to bring Mr. Shaw up here so I don't make a mistake. First matter is Brittany Blankenship. Discuss the matter with Ms. Sweatman, who's over from Walton County handling this matter. I'm asking that we put it on for 6/8. There's some financial information. The state has no objection to that.
Okay.
It's a
this-
restitution issue that we're dealing with, frankly.
Okay, and first of all, let me get appearances from the state.
Yes, Your Honor, Samantha Sweatman on behalf of the state.
And could you spell your last name, please?
Yes, ma'am. SWEATMON.
Thank you.
And Judge, I neglected to announce the case number 25 CF 1463 and 2378
I
are the
think
two
there's
matters.
one more, 25 CF
2387?
2387.
Thank
so
you,
there are
Judge.
three.
But all three will be disposed of on 6/8 if the court would allow us to continue it to that date.
Any objection?
No objection, Your Honor.
All right, all three cases will be June 8th, and you believe this will be the last one?
Yes, I do, Your Honor.
Okay. June 8th at 9 o'clock, pretrial conference in all three of Ms. Blankenship's cases.
Very well. The next matter, 25 CF 538, last name is Engel. And Judge, if we could leave this set without subpoenas, it will be a plea that day.
Okay, yes, I do have this one down as plea or trial. This
And it
is
will be a
Marie
plea.
Engel,
Yes, Your Honor.
25 CF 538. So docket day will be April 20th at 9 o'clock,
All right.
plea or trial.
Judge Jason Hall, we're asking for April 20th, same scenario as Marie Engel. I think that we've taken deposition in this case. The state and I have an agreement. It just hasn't been executed yet, so I'm going to suggest April 20th is the most sensible way to approach it.
All right. April 20th in Jason Hall, 25 CF 1691. That'll be 9 o'clock docket day, plea or trial.
Judge, we have Larry Goodson. It's under Mr. Shaw's name. He's dealt with that more than I have.
Yes, Judge, Larry Goodson, that's 25 CF 1670. We'd ask for a continuance on Mr. Goodson's case. There's a companion civil matter that's in front of Judge Stone, so we're asking for a one-cycle continuance to resolve it.
Any objection?
No objection. The state would ask that this be the last continuance.
All right. So you think you can wrap it up next time?
Judge, my office had offered up a bunch of dates for depositions, and 7 of them are before the next pretrial, so I'd assume we can, well, as long as we take the deposition of the alleged victim. He's the plaintiff in a civil lawsuit against Mr. Goodson, and same issues. So we've been going through a lot of this financial discovery in that case. So yeah, if we can get the deposition set before the next pretrial, I don't have any doubts that it can be resolved that day.
Okay, and you've sent dates for the deposition?
Yes, Your Honor.
Okay. When did you send those dates?
Friday, I think it was Friday, yeah, Friday, Judge. I've got the email here, and 5 of the dates are before June 8th, 2 more after June 8th. They're the 9th and the 10th, so.
Okay. Well, even if it's the 9th or the 10th, then hopefully you'll be able to
Right.
wrap it up next time.
Right.
All right, I'll put this down as a final continuance, and that'll be June 8th at 9.
Thank you, Judge.
Thank you.
Next case is Tyner Lee Atkins, 25 CF 2095. I believe, Judge, this may be the first pretrial we've had since we became involved in the case. It's an October 20th, 25 arrest, it appears. I have reviewed all the video that's been provided by the state. I do believe that there's going to be a specific discovery request based on that. There's some things that I don't believe were provided by the state, so I'm going to send them a specific discovery request with regard to that. We can put it on June 8th, that'd be great.
All right, any objection?
Without objection, just let me know when it is, sir.
Thank you.
All right, so that'd be June 8th, 9 o'clock, pretrial conference. And if you'll get that request over to Ms. Basso as soon as possible.
I will,
So
Judge.
we can keep things on track, all right?
Thank you. Stephen Allen Kitzler, Kitzler, 25 CF 2438. Also, Judge, asking for a 1-cycle continuance on that case. It's a December 16 date.
All right,
Your Honor, the state would ask that this be the last continuance. It's a possession case.
all right, so June 8th, 9 o'clock, that would be the final continuance on a simple possession.
Yeah, and I got to approach on one of Jay's.
The case would be 6 months old at that point.
Thank you, Judge.
Thank you.
May Mr. Basso and I approach on a separate matter?
Yes.
That's all I believe I have, Judge. Thank you.
Thank you. Mr. Sutherland?
Yes, good morning, Judge.
Good morning.
I had to run down to Judge Mason's courtroom, so I apologize.
Oh, no, you're right on time.
And so I'm here for Mr. Jeremy Gautreaux. This is case number 25 CF 1232. As an update in this case, we had the first round of depositions on April 1st. I like to try to get the officers and stuff done before the other witnesses in the case. One of the investigators from Wisconsin did not attend that deposition. He was unable to attend, so I have to reschedule his deposition. But I anticipate by the time I'm going to ask for a continuance today, and I anticipate by the time the next court date comes around, we'll have all those depositions done. There are 5 remaining depositions, one of the victim, her mother, 2 of law enforcement officers and 1 of a witness. And I additionally received another report at the last depositions, which I'm going over, which I believe is exculpatory.
All right. What's the state's position?
Without objection, ma'am, those depots are moving forward, and we'll make ourselves available for the next round.
Thank you.
So we'll give you dates.
Yes,
Have you set the dates or?
We have not set the dates yet. I had to get with my client on Friday about whether we needed to take a trip up to Wisconsin or not, but we're going to be doing them all via Zoom, so I anticipate we're going to get you the deposition dates by the end of the week.
Sounds great.
Okay, so let's do that. Depot dates to be provided by the end of the week to the state?
Yes, ma'am.
Okay. And we will set the case for June 8th. Pretrial conference, do you anticipate you'd be ready to go? Assuming you get the depositions done?
I can't represent that now, Judge. I'd need to see what happens at depositions and what information comes out.
All right. All right, so let's get those depositions done before June 8th. That means get the dates sent by the end of the week, and then the state will respond quickly with their availability, and hopefully we'll know where we stand on June 8th.
Yes, ma'am. Thank you so
All right?
much.
Thank you.
That's all I have. May I be excused?
Yes. Have a good day.
You too.
Mr. Gates? Good morning.
Now, I have 2 cases, and then I'm standing in for Byron Cotton, who also has 2 cases.
Okay.
Mr. Cotton's first case is Eldon Boskila, B-O-S-K-I-L-A, 26 CF 316. Mr. Cotton asks that this be left on the docket for the 4/20 docket day for entry of a plea.
All right, and who do I have for the state on this one?
Rachel Gaynor on behalf of the state, and that is correct. We've been in discussions and should be able to be on Monday.
All right. April 20th, 9 o'clock for a hopeful plea.
Next case, Stacy Kimmons, K-I-M-M-O-N-S. It's a 25 CF case. I don't know the exact case number.
25 CF 2005.
Your Honor, deposition of the alleged victim has already been taken. There's an offer that Mr. Cotton has not reviewed with his client yet, and I do not believe that the state has any objection to a continuance to the 6/8 pretrial.
That is correct, Your Honor. The state has no objection.
All right, and is the state ready?
Your Honor, we can call this the last continuance in this case.
Okay, this case is getting a little older, so we'll call it the last continuance, June 8th. That's 2 months to either accept or reject the offer and whatever else needs to happen. So June 8th, 9 o'clock, final continuance.
Yes, Your Honor.
All right.
My 2 cases, first one is Clinton Dooley, D-O-O-L-E-Y, 2026 CF 160. If we could leave that set for the 4/20 docket day. We entered into an agreement this morning for a misdemeanor plea, so I'll try to get that into the court before next Monday. If not, I'll be here on Monday.
All right. Mr. Dooley, 26 CF 160 is set for April 20th. That's Monday, docket day for a plea, unless there's a written plea filed before then.
Thank you.
Thank
And then the
you.
last case I have is Gavin Gutierrez, G-U-T-I-E-R-R-E-Z, 2026 CF 0055. We have the deposition of the alleged victim set for May 11th, so we're requesting a continuance to the June 8th pretrial date.
That's correct, no objection, Your Honor.
All right, this will be continued at the defendant's request to June 8th, 9 o'clock. And I think that's
all I
all,
have.
but I do need to see you and Ms. Gaynor on another matter, if you wouldn't mind approaching.
Not at all.
Thank you. Ms. Dudley? Good morning.
Yeah, I think the first one I have is Joseph Davenport in 25 CF 2013. And we have deposition scheduled for May 27th, so that's for continuance.
That's without objection, Madam. She's correct, that you already said.
All right. June 8th, 9 o'clock for pretrial conference, and this case is getting a little old. It looks like the arrest was in October. Do you think this is going to be the last round of depositions that you need to resolve the case?
I hope it's our first round, so if everybody shows up, then it's not a lot of witnesses, but if everybody shows up, we should be okay to get it resolved.
All right. So I'll put this down as last continuance. And, all right, next one.
The next one I have is Juana Gamble in 25 CF 1950 and 25 CF 2286. You know, we have a deposition set for May 15th on both cases, so that's for continuance.
Any objection?
No objection, Your Honor.
All right. June 8th, 9 o'clock, and this is continued at the defense's request.
Next I have is William Killingsworth in 23 CF 2156. We are set for the stand your ground hearing on June 11th, so that's for continuance.
All right. I have some other dates in May. I'm trying to keep the case on track because it has been continued 14 times and we are approaching 3 years old.
I think we had went through those dates with your assistant and there was an issue with the May dates. That's why we ended up setting it in on the June date.
There was issue with the state's witnesses, so all of the state's witnesses have been subpoenaed for that June 11 date, and we are set to go. We're ready.
Okay. And I know the last continuance was unavoidable.
Yes, ma'am.
I understand that.
But I believe we're ready for that date.
I know.
We've already make sure the witnesses are available, we're available, so we should go on that date no matter what.
Okay. So, June 8th at 9 o'clock. So let me just look at the trial dates. If we have pretrial on June 8th and we have that hearing on June 11th, the trial weeks are June 22nd and July 6th. So depending on the outcome of the hearing, assuming if it's denied, then
we can try for that second week.
We can try the case.
Yes, that second trial
Either
week.
June 22nd or July 6th.
Yes, ma'am.
All right. Obviously, if the motion's granted, then the case goes away, but.
There's no issue with that. We'll be ready for trial.
Okay, so this truly is the last continuance, and we're going to try this case either late June or early July if it has to go to trial.
Yes, ma'am.
All right.
The next I have is Quavion Seals and 24 CF 1560. And we have the motion to suppress set for May 14th at 2:30.
All right.
So that's for continuance for that.
Let me ask the state, is there any possibility of having that hearing on April 23rd, either morning or afternoon?
As long as my witness is available, Your Honor, I could do April 23rd. It'll be law enforcement, so unless this person's on leave or something, which I'm not aware of right now, I could absolutely do the 23rd of April.
Ms. Dudley, how do you
We
look?
already have a motion to suppress schedule with Judge Stone that afternoon, which may be linked these two co-defendants on a trafficking case. So I will try not to set another one if I can help it.
Okay.
But if the court's insistent, I'll make it work if I need to.
How about morning?
I have Walton County, so I'll have to be late, and I don't on that morning. But if you want to set an afternoon, I'll make it work.
Okay.
I would have to go between courtrooms.
Okay, so the reason is, this case is from 2024. I've said last continuance at every court date for the past year. And I know you've only been on the case since October, but
And it was based on the motion, it was based on the search warrant. We got the search warrant after that.
Yeah.
So that's why I filed it based on the search warrant. And that was it was sealed, had to get it unsealed.
Yeah.
It wasn't given to previous counsel, so that was the issue in getting the motion to suppress filed.
Okay. So, and I saw you file the motion in February. It just wasn't, I don't know what the delay was in setting it for a hearing, but I'm trying to move up the hearing so we can stay on track for this trial cycle. So if we hear that motion on April 23rd, it looks like our second trial week would be May 4th. Would that be enough time, depending on the outcome of the motion, to keep the case on track to be tried the week of May 4th? Would that be enough time?
Available, Your Honor.
Okay. Is that enough time to get your subpoenas out if it needs to go to trial?
Yes, Your Honor, that would give me enough time to get steps out.
Okay.
Be close, but
So we're going to reset the motion to suppress for the afternoon of April 23rd. That's approximately 2:30. It's just whenever arraignments are done, and I think I have some other things that afternoon, so it'll be heard that afternoon. I understand if you have to run between two courtrooms. So, Ms. Dudley, could you please file an amended notice of hearing?
Yes, ma'am.
All right, and we will keep this case on track for the May 4th trial week, depending on how that motion turns out.
Yes, ma'am. I did get retained on a case, Anthony Brown Jr. It's under Mr. Medina's on the docket. It's 26 CF 73.
Okay, let me find that, just one second. Okay, Anthony Brown Jr., 26 CF 73. I do see that on Mr. Medina's docket, and you've been retained?
Yes, Your Honor, I have filed my notice this morning.
All right.
So that's for continuance to the next pretrial.
I'll get discovery over you today.
Okay. All right, so I'm relieving the office of the public defender in 26 CF 73, Anthony Brown Jr. I'm recognizing Ms. Dudley as counsel of record, and we will grant the continuance at the defense's request to June 8th, 9 o'clock for pretrial conference. All right.
That's all I have, Aaron.
Thank you. That's a good question. Thank you for that. So, well, since the case is coming in on the afternoon of April 23rd, do you need to bring it in on Monday, the 20th, or what?
I would defer that to Ms. Dudley.
I don't think so, Your Honor.
Okay.
If for some reason we get it worked out, then I'll ask to add it, but I don't think so.
Okay, well, if you do get it worked out, we can always take it on the afternoon of April 23rd as
Yes, ma'am.
scheduled. So that's April 23rd at 2:30, and Ms. Dudley, you're going to file an amended notice of hearing.
Yes, ma'am.
All right, and we are not going to set it on the 20th. If you do work it out, typically docket day is my last day for a negotiated plea, but in this situation, since we're resetting that hearing, if you do have one that day, we'll take it that day.
Yes, ma'am, I appreciate it.
Sure, and then for whatever jury review or whatever we need to do, then we'll just play it by ear on the afternoon of April 23rd.
Yes, ma'am.
Depending on how the motion goes.
Yes, ma'am.
And sort it out then. Thank you.
All right, thank you, Your Honor.
So, thank you. Mr. Durrell?
Morning, Your Honor.
Good morning.
Yeah, Police Court, Dustin Durrell. Your Honor, my first client is Ms. Lacy Adams. It's 26 CF 311. Your Honor, we have received discovery. We're reviewing that. This is pretty heavily in a financial status case, so there's lots of bank records we're going through. If I may request a continuance from Ms. Adams.
Any objection?
No objection, Your Honor.
All right. Lexi Adams, 26 CF 311, continued at the defendant's request to June 8th at 9 o'clock.
And Your Honor, Ms. Adams' husband, Mr. David Adams, is a co-defendant. He's set on Wednesday's docket for some reason. Would we be able to go ahead and track the both of them together on that June 8th date?
Let me
That
take
is
a look.
26 CF 328.
Let me find that. All right, I'm not sure what that noise is. Yeah, I'm not sure why he's not in custody?
He's not.
Okay, I'm not sure why it's set on April 15th. This is case number 26 CF 328. And this is David Christopher Adams. There are two David Adamses on that court date. This is David Christopher Adams,
Yes, Your
26
Honor.
CF 328. And let me give Madam Clerk a chance to get caught up with me. Okay, you ready? You need the case number again?
No, I have the case number.
Okay. All right, and looks like I have Ms. Gaynor on this case as well. And you're asking for the June 8th?
June 8th date, yes, Your Honor.
I have no objection, Your Honor.
Okay. This will be continued at the defense's request to June 8th at 9 o'clock in Mr. David Christopher Adams, 26 CF 328, and that will remove him from Wednesday's docket. That's
Thank you,
April
Your Honor.
15th. Okay,
Thank you, Your Honor.
sure. All right, thank you.
Your Honor, my next client is Mr. Alexander Barbosa Rivera, 26 CF 115, requesting a continuance from Mr. Barbosa Rivera as well, still in the discovery process with that one.
Any objection? Okay. Mr. Alexander Barbosa Rivera, 26 CF 115, continued at defense's request to June 8th, 9 o'clock, pretrial conference.
Thank you very much. I believe that's all I have today.
Thank you.
Thank you.
Mr. Howell?
Good morning, Your Honor. How are you?
Great, how are you, sir?
John Howell on behalf of Mr. Byrd, 2025 CF 2393.
Yes.
Your Honor, we're working on finalizing a plea, which is going to include some jail times, just seeking a final continuance today.
All right, any hope of getting it resolved before Monday, or by Monday?
By this Monday, coming next week, Your Honor?
Yes, the 20th.
Your Honor, I don't know. I will talk to my client.
Okay. What's the state's position?
The state would just ask that it be continued to the June 9th, to the next pretrial conference date.
Okay. This is a relatively new one, so this will be a final continuance. When I say relatively new, it'll be 6 months old in June. So
Yes, ma'am.
last continuance, June 8th, 9 o'clock. And if you want to bring it in sooner, I'd be happy to take an early plea.
Yes,
Just
ma'am.
contact the clerk, they'll give you a date.
Perfect.
All right, thank you.
That's all I got, Your Honor.
All right, thank
Be
you.
excused. Thank you.
All right, that's where my list runs out, so I'm not sure who is next.
Andrew Albright, Your Honor.
Oh.
I'm here on behalf of Golem Farouk, 26 CF 242. Mr. Farouk, you can come forward. Your Honor, this is my first time appearing before this honorable court. I'm from Pensacola. Didn't know about the list, so I'm sorry about that.
No problem.
Okay. We've reached negotiated disposition in this case, subject to the court's approval, if I may approach.
Yes.
Okay, thanks.
And the defendant is present?
He is present, approaching the podium.
Thank you so much.
Thank you, Your Honor. We have a pretrial intervention agreement, and I have the plea recommendation and score sheet
All right.
all together up there for you.
That's great. All right. Sir, if you'll please raise your right hand. Do you swear or affirm the testimony you're about to give will be the truth? If so, say, I do.
I do.
Thank you, sir. You can put your hand down. And if you'll just state your name, please.
Ghulam Farooq.
Thank you, Mr. Farouk. You're here in case 26 CF 242, and you're charged with 8 counts of unlawful distribution of more than 16 grams of nitrous oxide, which is a third-degree felony, and each of those charges carries a maximum penalty of up to 5 years in prison. Have you had a chance to talk to your lawyer about all of those charges and any possible defenses?
Have you had a chance to speak with me about the case? To say yes.
Yes.
Have you discussed the plea and sentencing agreement and also the pretrial intervention agreement with your lawyer?
Have you discussed what we're doing here today with?
Yes. We discussed.
Did you read and sign the agreements?
Yes.
All right. Do you understand and speak English, sir?
Yes.
Okay. And can you read and understand English?
Yes.
Okay. Is this your signature on the last
Yes.
page of the plea agreement?
Yes.
And is this your signature on the second page of the
Yes.
pretrial intervention agreement? All right. Do you understand the rights that you give up when you enter a plea?
The rights you give up, right to go to trial, as we discussed, there won't be a trial.
Yes.
All right, I'm going to go over those with you just to make sure. Do you understand that you have the right to plead not guilty and go to trial, and you're giving up that right?
Which one?
The right to plead not guilty and go to trial, because we're entering a plea, there won't be a trial.
Yes.
So you just listen to the judge and answer the questions.
Yes.
None of these are trick questions. Mr. Farouk has never had a criminal case or gone through any of this before. I've discussed all of it with him. It's just a little bit nervous.
Yes.
I understand. So, sir, do you understand that you're giving up your right to go to trial?
Yes.
Yes.
Okay, do you understand you have the right to have a trial by jury in this case?
Yes, sir. Yes.
Do you understand that by entering into these agreements, you're giving up that right?
Yes.
That there won't be a trial if you enter into these agreements? Do you understand that?
Yes.
Do you understand that you have the right to remain silent and not incriminate yourself, and that you are giving up that right by entering into these agreements?
Yes.
Yes.
Do you understand you have the right to make the state prove that you are guilty beyond a reasonable doubt?
She's just going through your rights. Do you understand you have the right to have a trial? Do you have a right to require the state to prove the case? But because we're entering a plea, we're not forcing the state to prove the case.
Yes.
So you just tell the judge.
Yes.
Do you understand that you do have the right to make the state prove that you're guilty
Yes.
beyond a reasonable doubt?
Yes.
And do you understand you're giving up that right by entering into these agreements?
Which one?
The right to require the state to prove me guilty, so tell the jury.
Yes, yes.
Do you understand that you have the right to confront the witnesses against you and cross-examine those witnesses?
She's asking, do you understand you have the right for them to require witnesses to come to court and you confront them? By us taking this plea, there won't be witnesses coming that we're going to confront.
Yes, ma'am.
Do you understand you're giving up that right?
Yes. Yes.
Do you understand that you have the right to defend yourself by calling witnesses on your behalf and presenting evidence?
Do you understand, she's going through all your rights, do you understand you have the right to call witnesses? And because we're doing this plea, we're not going to call the witnesses?
Yes.
Go ahead.
Yes.
Do you understand you're giving up that
Yes,
right as well?
Yes.
Is there anything that I have asked you that you don't understand?
No, I understand you. This is fine.
Understanding that you're giving up all of those constitutional rights that I just went through, do you still wish to enter the agreement?
Yes. Yes.
Okay. Are you entering these agreements freely and voluntarily?
Are you doing this because you want to?
Yes.
Go ahead.
Yes.
Is anyone forcing you or threatening you to make you enter into these agreements?
No.
Is anyone forcing you or threatening you to make you enter a plea today?
No.
Has anyone promised you anything other than what is showing in these agreements?
No.
Are you satisfied with the services of your lawyer?
Yes.
Did he answer all of your questions?
Yes.
Have you had enough time to speak with him?
Yeah.
Have you had any drugs, alcohol, medicine, or any type of substance in the last 24 hours?
No.
I have a score sheet. It shows 8.9 total sentence points.
No objection.
Thank you. I'm not going to sign this score sheet since this is a pretrial intervention, and hopefully we will never need the score sheet.
Thank you, Your Honor.
Yes. In fact, well, I'll go ahead and file it, but it's not going to be signed because...
Understood.
Is there any exculpatory DNA?
None known to the defense.
All right. Any? Thank you. I do find a sufficient factual basis. I reviewed the court file last night. And I also saw that there is a motion to dismiss that was filed on March 20th.
That's correct, Your Honor. I filed the motion to dismiss shortly after the information was filed. After speaking with Mr. Ferris, we decided to resolve this case with the pretrial intervention disposition we have before the court. So I'd be withdrawing the motion to dismiss as we're resolving the case in this manner.
All right. And Mr. Farouk, do you understand what your attorney just said?
Yes.
Okay, that he had filed a motion on your behalf, a motion to dismiss, but you're not going forward with a hearing on that motion. Do you understand?
Yes.
All right. Do you understand that if you are not a U.S. citizen, that you could be deported as a result of this plea?
If you're not a U.S. citizen, you could be deported because of any criminal case.
Yeah.
But if you understand that, you can just tell the judge yes.
Yes.
All right. Is there anything else you'd like me to put on the record or inquire?
Nothing I can think of at this time, Your Honor. I did receive this paperwork from probation with the address and the pretrial intervention, so I'm providing this to Mr. Farouk, and I've instructed him that he needs to go there today after we get out of court this morning to get everything signed up and squared away so that he can get this taken care of.
All right, and Mr. Farouk, how do you plead to counts 1, 2, 3, 4, 5, 6, 7, and 8?
No contest.
I accept your plea. I
No.
find it was freely and voluntarily entered. In accordance with the agreements that you entered, you will go into the pretrial intervention program. And if you are successful in the program, you complete all of the terms and conditions, you don't have any violations, you don't pick up any new charges, then it appears that after a period of 10 months, then the state is going to dismiss the case. However, if you are not successful in the pretrial intervention program, or you violate the terms, or you don't complete the terms, or you pick up a new charge, then you will come back to me for sentencing. Do you understand that?
Yes.
All right. So I think I have Officer Howell, is that right? All right, Officer Howell is sitting right there on the front row, and you will need to see her before you leave the courtroom. Then, when you leave this courtroom, you will go straight to probation to check in, okay?
Okay.
Good luck, sir.
Thank you.
Thank
Thank you
you.
so much. Thank you, Your Honor, that's all I
Thank
have.
you.
May I be excused?
Yes, thank
Thank
you.
you.
All right, here are the leads. Thank you. Mr. Atkinson.
Good morning, Your Honor. May it please the court, Clay Atkinson with the record. I'm here today on behalf of Holly Boehner, who is president, approaching 25 CF 1711. Your Honor, if we could go to April 20th, we will have the case resolved on that day.
All right, and Ms. Baynard is present, and we will set the case for docket day, April 20th, that's next Monday, at 9 o'clock for hopeful plea.
Yes, ma'am, thank you, and that's all I have. May I be excused?
Yes, thank you.
Thank you. Good to see you, officer.
Good to see you. All right. Mr. Rare?
Good morning, Your Honor.
Good morning.
For the record, David Rare. The first case I have, Your Honor, is Devin Curry, co-counsel Mr. Lupellis, maybe under his name on the docket, and Mr. Curry is present. Judge, this is the second time up. We did our first round of depositions Friday. Ms. Gaynor for the state wasn't able to be there. She had some kind of conflict, so I wasn't able to do a follow-up conversation with her about how those depositions went. What I'd ask the court to do today, rather than full cycle continuance, if we can leave it set for docket day soft on Monday, I'm going to try to follow up with Ms. Gaynor this week and talk about the case and see where we might need to take it from there.
All right, and let me ask, you said something about somebody didn't show up for the, what did you say about the depositions?
We had two deponents on Friday. Ms. Gaynor wasn't able to be there. She had covering counsel for the state, so I wasn't able to have a follow-up conversation with Ms. Gaynor. It's her case, and I'm just trying to have that conversation with her the next week, if we could.
Okay. So you want to set the case for docket day, April 20th?
Yes, Your Honor.
Plea or continue?
Yes.
All right. April 20th, that's next Monday at 9 o'clock. Plea or continue in case 25 CF 2370. Thank you.
Thank you, Your Honor. The last case I should have on the docket, we just filed our notice on April 10th, so hopefully it's under us again now. And that is State of Florida versus Kayla Gamina with a G, 25 CF 1376. Ms. Gamina is walking up, Judge. This is the first up for a PTI recall. This is also, I believe, in Ms. Gaynor's case. If we could also set this for docket day, plea continue, I'm going to try to also have a conversation with the state in the next week.
All right, what is the state's position? And Ms. Gamina is present?
I don't have any objection. Just leave it on for Monday.
Okay. If there is a request to revoke the ROR bond, I would need an affidavit filed. So, all right. Monday, April 20th
Yes, Your Honor.
at 9 o'clock for docket day. Is that plea or continue?
Plea or continue.
All right. All right, thank you.
All right, I believe that's all I have in the docket, Your Honor. Thank you.
Thank you. All right, it looks like I have Mr. Williams present.
Good morning, Your Honor.
Good morning.
First, I have State of Florida versus Leroy Figures. That's 25 CF 2313, Your Honor. I'm going to request a continuance for a medical reason, Your Honor. My client has an appointment with the VA clinic this afternoon for possible heart surgery. Otherwise, I do expect the case is going to resolve. So it's just that I don't know that it will resolve by next Monday. So I guess I'll request a continuance to the next cycle. But if my client's medical issues resolve, to where we can get in here earlier, I'll get a hold of, do I call the clerk or your JA if we can get it earlier?
The clerk's office.
Clerk's office, okay.
Yeah, are there other dates? I know that Monday may not be available for council, but are there other dates in May perhaps that we could, rather than hold this all the way over until June 8th?
We have next Tuesday available. We have,
Which date is that, Your Honor?
that would be
Did you say next Tuesday, the 21st?
Yes, April 21st, we have that available.
Let me see.
We have the 23rd.
Oh, I'm out of town then, sorry. I couldn't do I couldn't do it next week, Your Honor. May 14th?
Yes, we have May 14th, May 19th, and May 21st.
I'm sorry, what did you say, after the May 14th, you're on 19th?
19th or 21st?
19th is fine, Your Honor, at 9 a.m.
Yes, May 19th at 9 o'clock. And is this going to be a resolution on that day?
Oh, I'm sorry, Your Honor.
Oh,
I'm so sorry. I saw that I had Judge Clark at 9 o'clock, and I thought that was you, but it was a different Judge Clark. I'm so sorry.
oh, that's fine. That's over in the 14th, right?
That was for the 19th.
Okay.
What did you?
I mean, the 14th Circuit. Yes.
Yeah, yes, in the
Okay.
14th, Judge Brantley Clark.
Yes. So I have May 21st. Does that work?
Yes, that'll work, Your Honor.
Okay, do you want morning or afternoon?
Afternoon would be best.
All right. May 21st at 2:30 approximately. It's just whenever we finish arraignments. And is that for a,
I think it's going to be, it'll be for a resolution of some sort, either that or set it for a trial, but I highly hopeful it'll be as a resolution.
okay. So May 21st at 2:30
Okay.
for a hopeful plea. I'm going to go ahead and set also the June 8th pretrial date
Okay.
at 9 o'clock. June 8th at 9. If
Yeah.
you find out before May 21st that May 21st is not going to resolve the case,
Great.
then please,
I'll do a continuance till June
or
8th.
notice of cancellation, we'll keep the June date. I'd rather, if we can resolve it on May 21st, that would be
Gotcha.
wonderful. But there's no point in coming in if, for whatever reason, it can't be resolved. We'll keep the June date then.
I understand, Your Honor.
Okay. All right, so we've got May 21st at 2:30 and June 8th at 9.
Gotcha.
Okay?
All righty. That's it. He doesn't have to sign for anything, does he?
All right, Mr. Figures, you need to stay in touch with Mr. Williams.
Yep. Your Honor, next I have State of Florida versus Jeremy Hargis. That's 24 CF 2793. Mr. Hargis is approaching.
Okay.
And Your Honor, the last time we were here, I told you there would be the last continuance. Unfortunately, I had one more witness to depose, and how can I say this? The witness there was another witness with the same name with the approximate birth date that was in DOC. And with the dates and everything, it looked like it was that witness, that was the person, but it was another person who had been in our jail, or your jail here in Okaloosa, but got released in February. So I kind of messed up. This deposition, I would not think is going to take more than 30 minutes. I've talked to Ms. Jardina, and we're going to get it set really, really quick. So
That's correct, Your Honor. Mr. Williams did call me shortly after we were supposed to have that deposition. Looks like there was an error made. I told him to just reach out to my office as soon as possible, and we'll get that last depo on the books. The state will be ready for trial.
Yeah.
Do y'all know where the witness is? Does anybody know where the witness is?
In the bar.
Okay, so
now.
you know where the person is, so you can...
I don't have the exact address, but I've talked to her on the telephone, so I shouldn't have any problem setting it up.
Okay, do you think you could get this scheduled, I don't mean the deposition to occur by Friday, but a notice?
This Friday? Oh, sure.
Yes. So notice
Sure.
of depo to be filed by Friday?
Certainly, Your Honor.
Okay. And whatever day that is, I think that's what, the 17th? April 17th. All right, so notice of deposition to be filed by April 17th. And this will be the final continuance.
Yes.
June 8th at 9 o'clock. So just so you can plan ahead and the state can plan ahead, the trial weeks for the next cycle will be June 22nd and July 6th. So we'll plan on resolving the case on one of those 2 weeks.
Absolutely.
Unless it resolves in some other way.
Very well, Your Honor.
All right, thank you.
Stay in touch. And that concludes my business.
Thank you.
Thank you.
Do I have any other private attorneys present? Oh, I see Mr. Catalinic.
Thank you, Judge.
All right.
Your Honor, I have one case on the docket.
Yes.
It's Miss April Willett Fleming Briggs, B-R-I-G-G-S. She's here present, Your Honor. 24 CF 1962.
Okay.
Your Honor, this case is going to be a play.
It's what?
It's going to be a play.
That is wonderful news.
Thank
All
you.
right, today?
Yes, Your Honor, it's going to be. Your Honor, 24 CF 1962, count 1 would be null pro. She would be pleading to count 2, and she would be adjudicated guilty, 10 years of probation, pay restitution in the amount of $52,750.48, minimum payments of $450 a month. She has to maintain gainful employment. If she's not gainfully employed, she has to complete 5 applications per week. She has to do an anti-theft class, $515 in court costs, and probation may terminate if all her obligations are met, meaning if she pays the restitution.
All right.
May I approach, Judge?
Yes.
Thank you, Your Honor.
Thank you. Thank you so much. Oh, that's okay. Excellent. I can read it. Thank you. And do I have a score sheet?
Is it there, Judge?
I don't see it.
No, that's my mistake.
That's okay.
I got it, Judge. If I can.
Sure.
It's 36 minutes.
Thank you. Are the costs $515 on count 2? Wonderful, thank you. All right, Ms. Briggs, if you'll please raise your right hand. Do you swear or affirm the testimony you're about to give will be the truth? If so, say, "I do."
I do.
Thank you, ma'am. You can put your hand down. And if you'll just state your name, please.
April Briggs.
Thank you. You are here in case 24 CF 1962. Count 1 is grand theft over $20,000, but under $100,000. That's a second-degree felony, and it carries a maximum penalty of 15 years in state prison. Count 2 is illegal use of a credit card 2 or more times within 6 months, and that is a third-degree felony with a maximum penalty of 5 years state prison. Have you had a chance to talk to your lawyer about those charges and any possible defenses?
Yes.
Did you discuss the plea agreement with your lawyer?
Yes.
Did you read and sign the agreement?
Yes.
Is that your signature on the last page?
Yes, ma'am.
All right. And on the plea agreement, it does say, I think the counts are swapped. It says count 2 is the grand theft. So
Yes, Your Honor.
what I'm going to do is, if you don't mind, renumbering them and, oh, I think that one's count, according to my docket, that one's count 1. And then, yes, and then the other one is count 2. And if she could initial that, that'd be wonderful.
Yes, Your Honor.
Thank you.
Just initial that right here.
What was restitution 2 and what was the first?
Oh, yeah?
Yeah.
All right. so much. Yes, I just want to make sure that the charges are numbered correctly. So the restitution is payable to who?
Should be Okaloosa County School Board.
All right. And I'm going to write that off to the side.
Yes, Your Honor.
And when is the first payment due?
I mean, the
Can we
5th
give her 60
or
days?
I would say the 1st of May, but I'm not super dead set on that.
We're asking for, Judge, we're asking for July, if the court will be okay with that.
How does that sound to you, ma'am? July 1st for your first payment?
Yes, ma'am.
All right, I'll write that down. And Mr. Catalinic, if you could have Ms. Briggs initial what I wrote on the side where I wrote.
Sorry.
Oh, no problem. That way she sees it.
Right here.
She's initialed it.
Just initial that right there. Thank you.
Thank you. Thank you so much. Ma'am, do you understand the rights that you give up when you enter a plea?
Yes.
Do you understand you're giving up your right to go to trial?
Yes, ma'am.
Do you understand you're giving up other constitutional rights as well?
Yes, ma'am.
All right, I believe those are laid out on the first page of the plea agreement. Do you have any questions about those rights?
No, ma'am.
Is anyone forcing you or threatening you to make you enter a plea today?
No.
Has anybody promised you anything other than what is showing on this agreement?
No.
Are you entering the plea freely and voluntarily?
Yes, ma'am.
Are you satisfied with the services of your lawyer?
Yes.
Did you have enough time to talk to your lawyer?
Yes.
Did he answer all of your questions?
Yes.
Have you had any drugs, alcohol, any type of substance in the last 24 hours?
No.
Are you suffering from any mental illness that affects your ability to understand what's going on?
No.
I do have a score sheet. It looks like it is, well, I have a question about the score sheet because I think there's a plea only to count 2, correct?
Yes, Your Honor.
There should be one that's marked out.
It is. I think that's count 2 that's marked out.
The grand theft should be count 1, and it's the 36 points.
That one should be on there or marked out?
And that should be on there.
What count is Ms. Briggs pleading to?
Grand theft to $20,000 or more.
Okay, so she's pleading to count 1?
Yes.
And the,
And the credit card count will be dismissed.
I gotcha, okay.
And I double checked, count 1 is the grand theft.
Thank you. All right, so I have a score sheet that shows 36 total sentence points. Any objections or corrections?
No, Your Honor.
Is there any exculpatory DNA?
Not that we know of, Your Honor.
All right, state.
No, Judge.
All right, I do find a sufficient factual basis based on my review of the arrest report. Ma'am, if you're not a U.S. citizen, do you understand you could be deported? I just need
Yes.
you. Oh, thank you. And it looks like you will be pleading to count 1. That is the grand theft, $20,000 or over, but less than $100,000. That's a second-degree felony with a maximum penalty of 15 years state prison. Is that your understanding as well? You're pleading to that charge?
It is now, yes.
Okay. Do you need more time to talk to your lawyer before I take your plea?
No, ma'am.
All right. How do you plead to count 1?
No contest.
I accept your plea. I find it was freely and voluntarily entered. Does the state have an announcement on count 2?
It's dismissed for plea to count 1.
All right. And in accordance with your agreement, on count 1, there will be an adjudication of guilt. You'll be placed on probation for a period of 10 years. You must pay restitution in the amount of $52,750.48 to the Okaloosa County School Board. You'll pay that through probation. Minimum monthly payments of $450 per month, and the first payment is due on July 1st, 2026. You must maintain gainful employment. If you're not employed full-time, you must complete 5 job applications per week and show proof of that to probation. You must complete an anti-theft class. $515 in court costs on count 1? Okay. And probation, it says may terminate after obligations are met. So it's not an automatic, it's a file a motion?
Judge, would it be automatic?
It'd be a motion. We wouldn't have an objection, just because we don't know what's going to happen between then.
Okay.
Okay. I mean, as long as there aren't any violations.
Yes,
and
sir.
all the terms and conditions are completed, and you've paid everything, you've done everything, you haven't violated any of the terms of your probation, then you can file a motion. You could just, ma'am, I don't know when this will be in the future, but if you handwrite it, that would be acceptable as well, as long as you file it with the clerk, make sure the case number's on it, and state clearly what you're asking to do. Then what I would do is set it for a hearing to make sure probation and the state don't object. Okay?
Okay.
All right. So may terminate probation, may file to terminate probation after you've done everything and paid everything. And as long as there are no violations, then that would likely be granted. So, but we'll set it for a hearing and see where we are. And did I cover everything?
I believe so, Your Honor.
All right, State, did I cover everything?
Yes, Your Honor.
Let me check with Madam Clerk, make sure I covered everything. All right. So, ma'am, you have 30 days to appeal the order of the court. If you cannot afford a lawyer, I'll appoint one for you. I wish you good luck. Please see Officer Powell. She's sitting on the front row. She's right over there before you leave the courtroom. And then when you leave the courthouse, go straight to probation to check in today. All right? Thank you. All right, do I have any other private attorneys present? I do have some on Zoom. Let me.
Judge Clark, my business is concluded. May I be excused?
Thank you. Have a good day. All right, good morning to those of you joining us on Zoom. And Mr. Ramey, do I have Mr. Ramey present? I do not see Mr. All right. Mr. Nopes?
Good morning, Judge. I've got one case, Murray Camillo. It is 25 CF 1608.
Just one
Judge.
second, if you'll just bear with me, because that case is not on my docket. Hold on just one second. Could you give me that case number again, Mr. Nopes, please?
Absolutely. 25 CF 1608.
Thank you. Let me bring up the case. I'm not sure why this case isn't on the docket for today. It just, the date didn't register.
Yeah, so we looked at the clerk's minutes from February 9th, and it said that it was continued to today's date.
Yes.
But
The date must not have saved in the system. Thank you for bringing it to our attention. Is Ms. Camillo present?
Judge, she normally appears in person.
Yes. Mary Camillo, are you present? I don't see her present. All right.
Judge, I just filed a motion to have a mitigation expert appointed.
Okay.
And so that was filed actually today. I do have an email address for her that I can attempt to email her and find out where she's at. I do not have a phone number.
Is there a waiver?
Well, let me look and see, Judge. Because I'm not certain we did a waiver, because I don't know that she's ever been here in order to do the waiver, been in my office.
Okay.
But, but I will tell you that she normally is in court, so I really don't know what happened.
All right. Let me see what the state's position is.
There is a waiver, Judge, actually. I don't see it. I just looked on my notes from December 8th, and I indicated that she was not present for December 8th, but that was because there was a waiver on file.
Okay, I'm looking for it. I can't find it right now, but I'm going to take your word for it.
I'll email her, Judge, and just make sure I can put hands on her.
Okay. So you filed a motion to appoint an expert today.
Right.
And you, I'm sure, attached the email from the JAC on that?
Well, we basically sent the email with our motion. We'll get an email back probably today or tomorrow, and then we'll submit the order to the court.
Okay, that's great. Yeah, I just need to review that email from the JAC before I can sign the order.
Absolutely.
All right, so what are you asking to do?
To continue it, Judge.
Okay. Any objection from the state?
No, Your Honor, I've not seen the order, or seen the motion yet, but looks like this would be the second continuance. No objection.
All right. I'm looking at a couple of things. I think this is going to be the third continuance. So this would be the final one.
Yes, ma'am, I understand.
Okay.
We just got our depositions done March 31st, and then the state and I have been discussing her prior points, and we had to check a few things out, but bottom line is that she does score prison time, and the only thing I can do to help her now is see if there's a mitigating situation.
Yeah, there's a lengthy prior history, so.
Absolutely.
All right, well, I'll be on the lookout for that order to come in to appoint the expert, and I am continuing the case at the defense's request to June 8th at 9. That'll be a final continuance.
Absolutely.
All right. Thank you, Mr. Nopes. I believe you have cases on Wednesday's docket, so I'll see you then.
Absolutely. Thank you, Judge.
Thank you.
Bye-bye.
All right, Mr. Rowe?
Good morning, Your Honor. I have one case on the docket. That's Peter Gawanowski. A little bit challenging to say and spell, but it's on your docket under G-A-W. And the case number, Your Honor, is 26 CF 0193. Your Honor, I'm requesting a continuance. Mr. Gowanowski, there is a waiver on file, but Mr. Gowanowski is in custody in Escambia County. Your Honor signed an order revoking his bond in this case. There are serious competency concerns, and Dr. David Josephs has been appointed in the Escambia case to do a competency eval. As of this morning, we do not have his competency evaluation yet. I'm going to file the necessary paperwork in the instant case to reflect what is happening in the Escambia case, but for now, I'm requesting a continuance.
All right, and just so Madam Clerk can locate the case, it's number 43 on the docket. I think it's under Mr. Mitkevich's?
Yes, Your Honor, Joseph Mitkevich's.
Thank you. So once you get the report from Dr. Josephs, if you wouldn't mind, do a notice of filing in this case, and we could use that report in this case as well, whatever it turns out to be.
Yes, Your Honor, we will.
All right. And what is the Escambia case number? I think I probably have it in my order revoking bond, but let me just put it on these notes.
One moment, Your Honor.
Sure.
That's 26 CF 0538.
Thank you.
In Escambia County.
All right. All right, so let me see, who do I have for the state on this one?
James Ferris, Your Honor.
All right, any objection?
No, Your Honor.
All right, so the case will be continued at the defense's request to June 8th at 9 o'clock, and that is in Peter Gowanowski, 26 CF 193. And Mr. Rowe, I know there was another case on the docket under Mr. Mitkevich's, but I believe it was Noel Prost on Friday. Just so our record is clear, that case is 25 CF 1345, Mr. Gustavo Alberto Duval.
Yes, Your Honor, thank you for bringing that up. I have been in touch with Ms. Gaynor, and we were on the phone when she filed the null pros on Friday.
Yes.
So thank you, Judge.
Sure, so that case needs to be, or it will be closed out. I just wanted to address it since it's on the docket, but I did see the null pros filed by the state. All right.
Thank you, Your Honor.
Thank you very much.
Have a good day, Judge.
You too, thank you. All right, Miss Liberty? Oh, you're on.
Good morning, Your Honor.
Okay, thank you.
Raven Liberty, on behalf of Sydney Cypress, that's going to be 2025-589.
All right, and I have Mr. Ferris for the state.
Yes, Your Honor.
All right.
So we did start depots. We had a bit of a complication. Those are being reset May 11th. This morning, I did, however, go ahead and file my motion to suppress, which I was waiting on. I got pretty much of everything I need from the body cam, and I have a motion to compel filed. Based on that, I would ask for a continuance, and I would inquire of the court if you would do the motion to compel ex parte, or if I need to set that for a hearing.
Unless it's agreed upon, it would need to be set for a hearing.
Okay.
So let me pull up the case. So I see the motions were filed today, this morning.
Yes, Judge.
And what happened with the depositions? I saw that they were scheduled for April 16th, which is this Thursday. What happened with that?
So we had scheduled based on the time, the availability of the officers. And so once my office had filed the amended notice of depositions, we were contacted by the state attorney saying they didn't have that date available. So they gave us May 11th. That should have been filed. If not, it'll be filed today.
Okay, so I guess I'm confused, because I see an amended notice of taking deposition filed on April 8th, and you're saying that...
Your Honor.
My assistant Olin coordinated with the sheriff's office and didn't actually coordinate with the state attorney. So when we set down the notice of deposition, it was with the availability of the officers and not the state attorney. So the state attorney wanted us to reset. We agreed. She offered May 11th, 2026.
All right. What happened to the May 31st deposition dates?
May?
Or March 31st.
March, there was an issue with the service. I had a conversation with the state attorney's office. They said once I did my notice of depositions, that would be sufficient. They'd get the witnesses there. There was some type of breakdown. Maybe it's my fault we didn't have the witnesses. That's why we were attempting to reset as quickly as possible, which would have been this week. The state attorney didn't have availability.
Your Honor, to the extent that counsel is indicating that we represented that we would serve her subpoenas, that it is incorrect.
Okay.
No, I concede. I said that may have been my misunderstanding in that conversation.
So we've got depositions that were scheduled but not served, and then we had depositions that were scheduled without informing us what those dates would be. We have provided several additional dates. May 11th is the date that's out there now. I recognize we've had 4 continuances. I see that this morning there were 2 motions that were filed. With respect to the motion to compel discovery, it's for a body cam video that I've already told her doesn't exist. So I'm not sure we can set that for a hearing. Certainly does not need to be a part of that.
It's actually not body cam video, it's the video from Coyote Ugly, which you see on the officer's body cam. She walks upstairs with the security guard to basically get the video. Security guard's looking for it. She says, all right, just contact me when you get it, I'll come back. That's the video I want. State has said they don't have it, so I'd want an official order compelling it, and they can file an official response because I believe it is Brady material. It would show what happened the 5 minutes that my client and her friends arrived at the club, where my client alleges they were punched in the face.
Hold on just a minute. Today is not the motion hearing. So let's
I know,
set the
Judge,
motion
sorry.
hearing, and we're going to set your motion to suppress, because I had today down as plea or trial. I advised everyone on February 9th that was the final continuance to today.
Your Honor,
And now
the state is
today...
ready for it, anxious for trial.
Yeah, and now today, just today, multiple motions are filed, and the depositions have been reset twice. Now they're beyond the trial date. So we're going to set those hearings now.
Okay.
And this case will be tried in the next cycle. So here are some hearing dates on your motion to compel. I have the morning of April 16th, that's Thursday.
Your Honor, that's the date the state is not available for the deposition, so we're also not available for the hearing. My apologies.
Okay. How about next Tuesday, April 21st?
Have that open, Judge.
Okay.
What time?
Well, everything is set at 9 o'clock Central Time. So it would be like the situation right now. It'll be set for 9 o'clock on April 21st. How long do you anticipate?
5 minutes, Judge. It's clear from the body cam, unless, if the court wants, I can send the snippet of the body cam to the court. You can review the conversation she has with the security guard. And I think that would be the crux of what we need to argue. I want that video from Coyote Ugly.
Your Honor, I will need to subpoena the officer who she's referring to so that she can be here to provide her testimony.
So is April 21st too soon?
If I get them out today, we can do it. We'll be rushing it, but we can get them out today.
Well, the alternative would be April 23rd in the morning.
That would make things a little bit easier on my assistant.
April 23rd, Miss Liberty?
So open. So if we were going to have the officer, an evidentiary hearing on the 23rd, could we also have the motion to suppress at the same time, because it would be with the same officer?
All right, let me check the schedule for the 23rd. How long do you think that would take? Obviously more than 5 minutes, but.
Yeah, I think probably an hour, 30 minutes for both sides.
All right, just 1 second. I'm checking another calendar on my phone. You would need to be here in person for an evidentiary hearing. I do have availability on the morning of April 23rd, and we can set that, we'll say 9:30 Central Time. That'll be right after jury review for 1 hour. So we will have the motion to compel and the motion to suppress both on that day?
Yes, Judge.
All right. And then we will figure out where we go from there. I'm really hesitant to continue the case at this point, but we'll address it on April 23rd.
Okay.
All right, April 23rd at 9:30 Central Time. And Ms. Liberty, I do need you to file a notice of hearing, please. And if you could file that today, that would be wonderful. So we'll hear both of your motions, April 23rd, that is next Thursday, 9 o'clock Central Time in person. Is the defendant going to be present as well?
She just had a small child. I'd ask if she could appear by Zoom. Meaning she just gave birth, sorry, she just didn't have a small child. She just gave birth, I believe, like 2 months ago, so I don't know. I believe childcare is going to be an issue at this juncture.
Does she live here locally, or is she living somewhere else?
No, she actually resides in Broward County.
All right, any objection to the defendant attending by Zoom?
For the evidentiary hearings, no, Your Honor.
All right, the defendant may appear by Zoom. Unless you were planning to put her on to testify.
No, Judge, I was not.
Okay. So, Ms. Liberty, you do need to be here in person, though.
I will be.
All right, wonderful, thank you. All right.
Thank you, Judge.
Anything else I need to cover on Ms. Sydney Cypress, 25 CF 589 today?
We're not setting a pretrial date at this point, correct?
I mean, I could for June, but I'm resisting continuing the case right now, but.
Why don't we just address it on the 23rd.
All right. We will, if there's a request for a continuance, it is tabled until the 23rd, which is next Thursday.
Thank you, Judge.
Thank you. See you next Thursday.
Yeah.
All right, Mr. Pumphrey.
Judge, thank you so much for calling this case back up. For the record, Don Pumphrey Jr. on behalf of Jeffrey Dodson. It's case number 25 CF 396.
All right. Okay, and I have Ms. Basso present for the state.
She's present. Judge, Mr. Patel said that the court set the case for docket sounding and trial,
Yes.
either 4/27 or 5/4. I am unfortunately, in 2000, I believe 24, I planned a trip to Europe. Doing a transatlantic crossing. It is paid for. I can't change it. It's the longest period of time I've taken off in 27 years in private practice. The flights, the flight back I could probably adjust, but I actually had it adjusted for another case that was set for trial because I set my plane flights in January. That case has gone away. I understand the court's wanting to set it for trial. This is an older case. We received the discovery that the state thought they had sent or did send and we didn't receive, whichever, in March. We've done depositions. We received the transcripts, I believe, around the 7th. We forwarded those to the expert. I received a response from my expert who's in Arizona this morning at 7:37 a.m. and advising of what else is outstanding on our pending motion to compel. I have a short list. I've not even had a chance to draft an email. I spoke with Mr. Patel this morning. The only thing he didn't know was my pre-planned vacation. So I can be available the 23rd. I have a restitution hearing in juvenile court, but that may or may not go. I haven't received the amount from the state. And Judge, this particular defendant, Mr. Dodson, I've talked to him twice, both this morning before the hearing, and I spoke to him when I got free, and Mr. Patel notified me of the case being set. He doesn't have access to the internet, and so he can't do Zoom unless the court does a specific order allowing him to do Zoom for appearance in court.
What are the dates of your trip?
Judge, I'm scheduled to actually leave for Fort Lauderdale on the 23rd of this month. I have a client in the Broward County Jail that I was going to meet on the 24th. I board the ship on the 25th, and I actually have cut because I had another case that had come up, and I was able to change my plane flight for the 15th to fly out of Naples, arriving in the United States on the 16th. So I'm gone.
Of May 16th?
Yes, ma'am. That's the longest I've ever taken off.
Okay.
It's a transatlantic crossing. It goes to Bermuda, and then several places in Spain, and then ends in Barcelona and picks back up and goes through the Med to Italy, France and Italy. And it was planned specifically with this ship because it's, I guess they do transatlantics. I did a trans-Pacific last year. So.
Okay.
Mr. Patel did not have that information this morning.
Right, okay. December the 8th, I said that's the final continuance. And I continued the case to February the 9th. On February the 9th, Even though I said that was the final continuance, I granted yet another final continuance to today. So,
And Judge, I believe that continuance was granted for the state to provide discovery, which the state did. I got that immediately to the expert and went ahead and set depositions before the expert was able to get me what I received this morning back so we could move this case along. I think we can set it for trial. I just want to advise the court that the insurance I have on that trip doesn't account for court appearances. Delta always will give, will at least give you credit, but that's to get me back to the United States. So either it's a no-go or a go. But I'm glad to pick a trial date now. And if the court is open and the state doesn't have any objection, I can see if I can arrange for the defendant to appear via Zoom for any court appearances. Otherwise, he'll have to travel. He's in Kentucky, I believe.
what is the position of the state?
Ma'am, certainly we'll do whatever the court wishes us, but however, I have been in touch with my primary witness, the one that was a 3-hour deposition. He is in mandatory training for 2 weeks, and then will be an instructor in a case that's in a course that's already in place. And that's between 419 and 5-1, and 5-2 and 5-8, so it falls right in our trial weeks as well. Now, if the court wishes, based on what Mr. Pumphrey has indicated, it sounds like he would be ready for the next trial cycle. My witness is available in the next trial cycle, but certainly we will do as the court directs us.
All right, here's what I'm going to do, because it sounds like the state has issues as well. This case will be tried. We're going to set the trial date right now, and we're going to set other deadlines.
Yes, ma'am.
Mr. Pumphrey, you said something about a motion to compel that you need to file.
No, ma'am, that was filed. The court heard it, and we took it under advisement because the state provided, and we received additional discovery. And so we sent that to the expert, but I went ahead and set the deposition, even though I didn't have all the discovery, or what the state had sent. And the expert is identifying several things. I was going to email to Ms. Bosow to see if we could resolve that without a hearing and an order.
Okay, yes, actually.
That's why.
I didn't take it under advisement. We were scheduled for a hearing, and then the motion was, the hearing at the defense's request did not go forward, and if my memory serves correctly, it was going to be reset if needed, I believe.
That's correct, Judge.
Yes.
And this morning, when we received it, we sent it out to the expert who's in Phoenix. And this morning at 7:37, I actually called the client, Mr. Patel, because I received a response from the expert identifying a few items that we don't have. And I want to cross-check those with Ms. Bosow and see if we can get those. Or if they exist, there's 2 items that I know don't exist after the depot because the detective did a wipe on the device. So we're not trying to delay it.
Okay.
In any way, and I was just trying to save the court and the state trouble because I believe the state, I've worked with Ms. Bosow before, she's very good about getting things to me, and that's usually not where the issue is. It's usually with law enforcement or something else, and I have a narrowed list. She's provided most of the things on the previous motion to compel, but I'm not ready to withdraw it at this time, but I think we can set it for trial. If the court can tell me the trial cycle dates, I have my calendar pulled up. We'll set it for trial. And Mr. Patel was retained as local counsel because he's right there and he can appear if I can't.
Okay. So I would like to set a discovery deadline, a motion deadline, and other court dates. So what is a reasonable period of time for you to complete discovery?
Judge, I think, depending on, Ms. Bosow's in contact with Detective Evans. I think she and I can get on the phone. I can send her an email, and that'll determine one way or another. The only issue outstanding is the availability of the expert. And that's why I was recommending, I know the court wants it tried, but I was recommending we go ahead and set it, not just continue it, but set it on a trial docket that we know we can get everybody there. There's a time difference, the expert's in Phoenix, and so if the court wants to leave this set for the morning of the 23rd, I can have Mr. Patel up here, and we can have the dates worked out between your JA and the state attorney, and have proposed trial dates when the experts are available.
All right, I can give you the trial dates now, and we can go ahead and schedule it. I don't know if we need to have the 23rd or not, but what is a reasonable time for you to complete discovery?
The discovery should not take more than 30 more days. I may have to depose the detective again on additional information we received, but like I did last time, I can see if Ms. Bosal has some available time for me to depose him, not on what he's previously been deposed on, but on the issues that are outstanding, and then we should be set. So I would say 60 days at the outset, but
That's going to be beyond our next pretrial date.
when is your next pretrial date, Judge?
June 8th. And
I would,
discovery has to be completed, and all motions need to be heard prior to that date. I understand with your vacation, that's going to knock you out for a good part of the time, or at least about 3 weeks or so of the time between today and June 8th. However, discovery needs to be completed, all motions need to be heard, so that we can stay on track.
very good, Judge.
So what would be a reasonable time to complete discovery?
I don't know why it can't be completed by June 8th.
Would you need to complete discovery in order to prepare motions that would need to be heard?
I would, Judge.
Okay, I need to have your motions heard prior to then.
Prior to the June 8th date.
Yes, it's going to be very difficult. I'm looking at my June calendar. I don't have time in June for a lengthy motion. Those are all filled already, those dates. So
When you say lengthy, Judge, how long are you talking?
more than 30 minutes.
Yes, ma'am. I don't anticipate many motions. The only thing that may exist is there may be a motion to dismiss, but I won't know until I get the rest of the discovery. But even so, I don't think that would take 30 minutes, unless the state and I have to put on testimony.
Ma'am, it sounds like we should be able to get a discovery completed within 30 days at the outside. As soon as Mr. Pumphrey knows what he believes is missing, we will have an opportunity to discuss it. I would ask also, sir, that if your expert is going to be called, that that be disclosed, and that any reports that he or she prepares be made available so that I can set a deposition if I have to, and we can keep it rolling as long as they're available.
Can you hear Mr. Pumphrey? Ms. Boswell?
I can barely hear, but I think I got it. She is wanting.
I'm going to ask her to get to a microphone.
I will.
She's going to get to a microphone and repeat.
Yes, Mr. Pumphrey, basically what I said, sir, is I suggested in 30 days, we should be able to do it with no problem. As far as discovery, if you just let me know what you believe is missing, we can talk about that. If your expert is going to be used, if he or she prepares any reports, if you can get those to me and make them available, should I need a deposition, I think we can roll it all pretty fast. But within the 30 days, I think we get the discovery process at least done, and then if the court wants to give us a motion date, then we can go ahead and set that. It sounds like it would have to be in May.
Yes.
To meet the June deadline.
I'm good with that. I will advise the state that she hasn't rendered any opinions yet. She's just told us what we're missing and what she needs to make an analysis. And she has a very busy schedule, so in deference to the state wanting to depose her, all I have to do is get her all the discovery.
Okay. I'm setting a discovery deadline of 30 days from today. That is May 13th. That's before you get back from your trip. So,
Judge, the nice thing about this trip is I have access to the internet. I actually get more work done. So it's a good time to,
good news. All right, in that case, motion deadline for filing. I'm looking at my hearing dates. Well, how long of a hearing are you anticipating needing? How much time?
are you addressing me, Judge?
Yes, I'm wondering if it's
My
going to be
apologies.
more than 30 minutes or less than 30 minutes.
I won't know until I talk to Ms. Bosow and we get the additional items that were sent to me by the expert this morning.
Okay, I have a motion date available of May 21st to be heard, which means the motion's going to have to be filed enough time prior to that date so that if any witnesses have to be subpoenaed, then there's time for the state to do that. I don't know
And,
what...
Ma'am, for my witness, what I would anticipate, as long as the witness is available, I have no trouble just picking up the phone and calling that particular witness. We work pretty well together. So we won't worry about that part of it. We'll just worry about getting the motions filed and set.
All right, I'm setting a motion hearing date. If there are no motions to be heard, it will be a status date. That is May 21st at 9 o'clock Central Time. So let's back into the motion filing date. If the motions are going to be heard by May 21st, they have to be filed in sufficient time for the state to review and make whatever arrangements they have to make. So, Ms. Bosso, how much lead time do you need with the discovery cutoff of May 13th and then the hearing date of May 21st? What's the filing date?
Ma'am, the Friday is 5:15 or the 18th would be fine. Either Friday or Monday first thing. Not close of business, please, sir, on the 18th.
Okay, so
5:13 is the deadline on
discovery?
discovery and filing of motions.
Well, I was going to say 5:15 at the close of business, so 5 o'clock
That'd be good, ma'am. That gives me enough time.
is the filing deadline for motions. Any such motions will be heard on the morning of May 21st at 9. We've got a pretrial conference scheduled for June 8th at 9. Let me give you the other dates, Mr. Pumphrey, that go along with that. Docket day would be June 15th at 9 Central Time. Jury review, I'm not setting these just yet, I'm giving you the dates. Actually, I probably ought to go ahead and set them, just so
Judge,
they're in the books.
Let's set them.
I have a trial on the 15th
Of June?
of June, 23 CF 1453, Leroy Young.
Okay, well,
I hope that goes to trial, but it's set for that Monday for jury selection and tried sometime that week, but,
well, I'm sure Mr. Patel can appear on the 15th.
And then the trial weeks, ma'am?
Yes, and let's say, jury review is June 18th in the morning, 9 o'clock.
and judges, so I have the nomenclature, I don't get over your way very much, and I haven't appeared before your honor for trial. So is jury review, is that jury selection?
No, that's the cases that are going to trial, and we work out what days they're going to go
Okay.
the following week, or the week, the next trial week. So on jury review, that's when we do our scheduling. So let me give you the trial weeks, and you two can look at your calendars right now and tell me which one you want. June 22nd or July 6th. We'll go ahead and set the trial. Those would be the jury selection dates, and then trial would be, the date would be worked out at jury review.
Judge, the July 6th date,
I would second that now.
July 6th. That is your jury selection. I start at 8:30 in the morning Central Time for jury selection. So let's recap. You have a discovery cutoff of May 13th. Any discovery y'all do after that is at your own risk, but it's not going to be grounds for a continuance. Your motion filing deadline is May 15th at 5 o'clock. I've already scheduled a hearing date for those motions. If there are no motions, then that would be a status date to make sure we're on track. If you don't get your motions filed by May 15th at 5 o'clock, they're waived. Your motion hearing date is May 21st at 9 o'clock. All these times are central.
May 21st at 9 o'clock?
Yes, central time. That would be in person.
Yes, ma'am.
And then you've got pretrial conference, June 8th at 9 o'clock. Docket day, June 15th at 9 o'clock. That is the last day I will accept a negotiated plea agreement. After that date, it's either, well, it'll have to be a plea straight up to the bench if there's going to be a plea.
Yes, ma'am.
Jury review, that's the scheduling of when we figure out what day the case will be tried. That is June 18th at 9 o'clock. And your trial date is July 6th. This is jury selection. July 6th at 8:30. Now, I don't know what day y'all are going to go that week. We'll figure that out at jury review.
We'll just select a jury that day and
Correct.
and we'll decide what day after that.
Yes,
Understood.
and, you know, I don't know if y'all are going to want to do a pick and go or have it the next day. We'll just have to figure out what day during that week the case will be tried, but all juries for that trial week are selected at 8:30 on July 6th.
And Judge, as I know that the defendant needs to be present
Yes.
on July 6th, as to the other dates, since he has the ban on appearing or access to a computer, if he is able and allowed, can he appear via Zoom for whatever dates the court needs to verify?
Yes and no.
Yes, ma'am.
He would need to be present for any motions, obviously. So if you send me an order, as long as he's not going to testify, if you send me an order, I'll authorize a Zoom appearance. That would be the May 21st date. He needs to be present in person on June 15th docket day, because on that day, that's the last day I'll accept a negotiated plea. I'm going to have the state put their offer on the record, and I'll go through a colloquy to make sure that the defendant understands. So he does need to be present for that.
Yes, ma'am.
And then, of course, he'd need to be present for jury selection.
Very good, Judge. So just to recap, on June 15th, he needs to be present so the state can announce the offer, and he can either accept or reject it. After that, it's a straight-up plea.
Yes.
He'll also need to be present for the motion May 21st at 9 a.m. Central Standard Time. And if I prepare a proposed order and send it to you in the state, the court will allow him to appear by Zoom if he can. If he cannot,
Yes.
I know he can appear via phone, but otherwise he has to be in person.
Well, he can appear by phone as well. He can call into Zoom.
Okay.
And the same for jury review on June 18th. He can appear by phone or Zoom. But the dates he needs to be here in person are June 15th and July 6th.
I think I have it, Judge.
Great. So I'm going to ask you to please prepare an order with all of those dates.
I was already thinking, do you guys call it the Blue Man or the recording system? I was gonna order that, and just make sure we're all on the same page and prepare an order.
If you will just prepare the order, I made notes. If I see an error, I'll correct it.
Yes, ma'am.
Or you can give me a call tomorrow if you'd like to, sir.
So if you could please send over an order quickly, like within the next few days, before you, I know you're leaving
ma'am.
next week, so that way we can get the order entered, everybody's got the dates in writing, and I'm sure the clerk probably wrote them down too in the minutes, but thank you very much, Mr. Pumphrey, that'd be helpful.
Bless her heart, Judge, but I took notes as well. I just always like to double check anything. Judge, the only thing I haven't received is a response from my expert. I went ahead anticipating we were going to set it for trial. I don't know if my expert's available or not. That would be the only issue. That week is clear, and I'm about to clear the whole week.
Well, if your expert is not available that week, then that means it needs to be June 22nd. Those are the options, June 22nd or July 6th. So check with the expert and find out which week works best.
Yes, ma'am.
All right.
I will do. Thank you so much for your time and
Thank you.
patience, Judge, and Ms. Powell. Always appreciate working with you.
Thank you. All right.
May I be excused?
Yes, thank you, sir.
Thank you very much.
All right, Mr. Harper.
Good morning, Judge.
Good morning.
If I can start with number 58 on the docket, Charlie Bautista.
All right. That's 26 CF 220,
Yes, Your Honor.
and she is present.
Judge, this is the first time up for Ms. Bautista. Can you stick around? I'm going to give you my contact. Okay. Judge, I would ask for a full cycle continuance based on the nature of this offense.
Any objection from the state?
No objection, Your Honor.
All right, continued at the defendant's request to June 8th at 9 o'clock, pretrial conference.
Yep. Thank you, Judge.
Thank you.
Next case I have is Sherry Black. And for the record, Judge, Ms. Bautista was 26 CF 220.
Yes.
Sherry Black is before the court on 26 CF 116. She is present.
Mm-hmm.
Your Honor, we don't have discovery yet. This is the first time up. If I can leave her set for docket day to see this, if this is a case we can resolve this cycle and bring her back on the 20th.
All right.
Your Honor, it looks like whenever I filed the discovery, it was before Mr. Harper was on the case. I did send my assistant this morning an urgent email to get him that link today, so he'll have it by the end of the day, if not already, provided to him. The offer is a withhold, it's a probation offer. So I agree, let's leave it on Monday because it's very likely we could get it resolved.
All right. And then I will set Ms. Sherry Black's case for docket day, April 20th at 9 o'clock for plea or continue. All right. Thank you.
The next case, Judge, is Nicole Brockwell, number 60 on the docket before the court on 25 CF 1767. She is present and approaching. Judge, this is an older case. I'm inclined to leave this set for plea or trial. I've sent over, Ms. Brockwell just provided me with some reciprocal discovery. I sent that over to the state, and they should get it this week. But I'm hopeful we can come to a resolution this cycle, Judge.
I do have it down as, this is the final, this is the date. On February 9th, that was the last continuance, so this is plea or trial. Do you want docket day?
Yes, ma'am.
All right. Docket day, April 20th, plea or trial. So that would be the last day I would accept a negotiated plea.
Yes, ma'am.
All right. So, ma'am, you do need to be present on Monday, April 20th at 9. Thank you.
The next case, Judge, is Molly Chamberlain, 25 CF 2350. She is present and approaching.
All right.
Judge, she has advised me that there is something that she needs to provide me so I can provide the state. She anticipates she'll get that this week. I'm hopeful that if I can provide that to the state as reciprocal, we can resolve it this cycle, and I'd like to leave this set for 4/20 docket day.
All right. Docket day, April 20th. 9 o'clock. I'll put it down for plea or continue.
Okay.
All right, thank you, ma'am.
The next case, Judge, is Tangela Collins, 26 CF 19.
All right, and she is present.
Judge, this is the first time up on Ms. Collins' case. I have not spoken to her about how she would like to proceed in this matter, but given the offer and the nature of the case, if we can leave her set for docket day, I'm hoping that we can come to a resolution. This is the first time up, Judge.
Any objection?
No, Your Honor.
All right. So continued at the defense's request. June 8th, 9 o'clock, and Ms.
It's 4:20.
Mr. Harper, did you say docket day or?
Oh, I'm sorry, did you say docket day?
Yes, ma'am,
I'm
docket
so
day, it's a
sorry.
probation offer, and
So sorry. That would be April 20th. Docket day, that's next Monday at 9 o'clock. I'll just put it down for plea or continue. April 20th, Monday, 9 o'clock. All right, and ma'am, make sure Mr. Harper has your contact information, okay?
what's your phone?
And that you have his.
The next case, Judge, is Nick Combs, 26 CF 143.
Okay,
He is present
26.
and approaching.
All right.
Judge, this is also the first time up, and based on the nature of the charges and the offense, this is a withholding probation offer. I've spoken to my client, we had an appointment before today, but we do have one particular thing that we want to get addressed, and I'll convey a counter offer to the state. If we can leave this set for docket day, I think we can come to a resolution this cycle.
Docket day, that is April 20th, that's next Monday at 9 o'clock. I'll put it down for plea or continue. Thank you.
The next case, Judge, is Angelina Copeland, 25 CF 2435, 25 CF 2452, and 26 CF 17. There's a waiver of appearance in her cases. One of the cases is the first time up. I believe two of the others are second time up. I would ask for a one-cycle continuance. My primary concern is the Berg dwelling. We're going to do depositions in this matter, and I'll get that set as soon as possible.
Any objection from the state?
No objection, Your Honor.
All right. So all of Ms. Copeland's cases, there are 3 of them, are going to be continued at the defense's request, June 8th, 9 o'clock. All right.
Yes, next case, Judge, is Charles Crane, 23 CF 2695. He is present and approaching.
Okay.
Your Honor, we have retained an expert in this matter, Dr. McDonald, to pursue an insanity defense. Unfortunately, her first available appointment is mid-June, and that's not including any reports that she generates or if she needs to collect. We'll try to get releases for any medical records and stuff like that in advance, but I just wanted the court to understand the context of where we're at with respect to scheduling on that. I would like to continue this to the next cycle. Okay, I'll write on this paper. It is an older case, Judge, I understand, but there have been some competency issues and other things that sort of.
Okay, so on February 17th, there was mention of getting an evaluation with Dr. McDonald. I ordered the defendant to attend the evaluation. So,
It's not a competency matter, Judge. I
Okay.
think that's been determined by previous doctor, and his disposition hasn't changed since then, but based on the nature of the allegations and his behavior during that time frame, I believe that an insanity defense might be warranted in this case, and that's what Dr. McDonald's availability is, unfortunately.
okay, and so on October 20th, 2025, December 8th, 2025, and February 17th, 2026. Those were all last continuance. I've got it down as plea or trial this cycle. What is the state's position?
Here in the States, been ready for trial, we're still ready for trial. I think we've announced that multiple times on previous court dates. I think we can push it for trial if there's an insanity evaluation still pending.
Okay, and this is not a court-appointed,
No, judges. We can't court appoint someone, I believe, for an insanity defense.
I do think, which of course with Mr. Harper, it's a good faith evaluation.
all right. When is the evaluation?
Your Honor, she said mid-June. I don't recall off the top of my head. I can try to find it. I think it was like June 15th or...
Okay, so that appointment needs to be scheduled and confirmed
Yes, ma'am.
within 24 hours.
Okay. And I'll provide that to the state.
And Mr. Crane, you'll need to attend that evaluation. Do you understand that, sir?
Yes, ma'am.
Okay.
I haven't missed no evaluations
All right.
or appointments.
And he's been good with communicating with me as well, Judge, so.
Okay. So I don't know if this is something where you need to file a notice in the court file of the date of the evaluation, or just send notice to the state, but
I can do a confidential filing.
whatever you want. I just want to make sure that the appointment is scheduled and on the books within 24 hours.
Yes, ma'am.
So we will go ahead and grant a continuance since you have to get the evaluation June 8th. Now that's probably, your evaluation is probably not till after that.
Yes, ma'am.
If you're saying mid-June, but June 8th, 9 o'clock is your next pretrial.
Okay. All right, the next case, Judge, is Stephen Davis. He's before the court on 24 CF 2952. He
Okay.
is present in session.
All right. And 24 CF 2952. First of all, I have a note that the defendant needs to update his address with the clerk of court. Mail's being returned from the 221 Carmel Drive address. pretrial conference.
Judge, the next case is Tyrone Hensley, number 70 on the docket. Is present and approaching before the court on 25 CF 1578.
Okay.
Judge, this is a fairly straightforward case. This is a bit of an older case as well. I advised Mr. Hensley that it's been my intention to leave this matter set for plea or trial. He's advised me that he's been in contact with Kilpatrick and Newland to retain private counsel. He's met with them. He has their contact information. I didn't see that anyone's filed a notice of appearance or anything of that nature, but
Okay. I do have this down for plea or trial. I announced on February 9th that that was going to be the last continuance.
Yes, ma'am.
So, sir, have you already hired?
We haven't retained them yet. I'm going to be meeting with them again. What I'm trying to do here basically is get somebody to actually sit down and go over frame by frame of the body cams on this case. I have a co-defendant as well. And I'm basically think I need a second opinion and more representation. No offense toward Mr. Harper at all.
Okay. So I'm setting your case for docket day, that's April 20th. Let me see if is the state ready?
Yes, Your Honor, as Mr. Harper said, this is a pretty straightforward case.
Okay. So, April 20th, docket day, plea or trial. Do you have an appointment already scheduled?
I've already met with them at one time.
Okay.
And what I've got to do is basically just get on the phone and call them. I don't know if they will.
Okay.
I mainly wanted a second opinion from them, but we probably will retain them.
Okay, you need to do that quickly.
Okay.
Because I've set your case for next Monday, April 20th at 9 o'clock.
Okay.
Plea or trial.
All right.
All right,
yes,
that's
ma'am.
docket day.
the next case, Judge, is Tiara Hawley, 25 CF 1324.
Okay.
She is present and approaching.
Okay.
Judge, this matter is also an older case. We're going to leave this set for plea or trial. I'm anticipating we'll probably resolve this on docket day, but in an abundance of cautions, if we can just leave this set for trial.
All right. Is the state ready?
Yes, Your Honor.
All right. 25 CF 1324, Ms. Tiara Hawley is set for docket day, April 20th, 9 o'clock, plea or trial. That'll be the last day I'll accept a negotiated plea. All right.
She has an appointment with me on Friday.
Oh, great. Thank you.
The next case I have, Judge, is Summer Holmes, 25 CF 2352.
Okay. And she is present and approaching.
Judge, there's some complicating issues with respect to some collateral. I've spoken to the state about it. If we can bring her back on docket day, I think this will be resolved on that date. If we can just leave a separate plea or continue. It's less to do with this case and in another case that she's the victim in.
Okay. So April 20th at 9 o'clock, docket day, plea or continue. All right.
Okay. Next is Lauren Hyman, 25 CF 1641.
Okay. And she is
Present.
approaching.
Let me have just one moment, Judge.
Sure.
She's before the court on 25 CF 1641. She's going to withdraw her previously entered plea, enter a plea of no contest. This will be an adjudication of guilt. She'll be placed on 3 years of probation. Be assessed $515 in court costs, $150 cost of defense. She'll have contact with the victim as allowed by Georgia courts, and there's case number 20 22 RCJP-24, which currently allows for supervised contact as allowed by the father. There is 1 year probation on count 2, and we're asking to run that concurrent. And I believe the state might file a score sheet later.
Yes, ma'am, that is the state's agreement. I will put on the record that this is not a downward departure. She scores to 39.2 points. I do apologize to the court after we get it out of the printer, but I will have it to the court today.
Okay, so thank you. Thank you so much. What county is the Georgia case?
Richmond, Columbia County, I'm sorry.
Columbia
Yes, ma'am.
County. All right, let me write that down.
Actually, it says Richmond County.
Yeah,
Richmond
yes, sorry.
County?
Yes, ma'am, you might be right. I had to think about it for a second.
It's the juvenile court of Richmond County, ma'am.
Let me write that down.
Almost said Richmond.
I just wrote that on here so that probation will be aware of, they need to find the case, they can find it.
And if they need a copy, we can provide it as well. We'll have a copy.
All right. So, ma'am, if you'll please raise your right hand. Do you swear or affirm the testimony you're about to give will be the truth? If so, say, I do.
I do, yes, ma'am.
Thank you. You can put your hand down. And if you'll state your name, please.
Lauren Ashley Hyman.
Thank you. You are charged in case 25 CF 1641 with 1 count of child neglect without great bodily harm. That's a 3rd-degree felony with a maximum penalty of 5 years in prison, and 1 count of possession of drug paraphernalia, which is a 1st-degree misdemeanor with a maximum penalty of up to 1 year in jail. Have you had a chance to talk to your lawyer about those charges and any possible defenses?
Yes, ma'am, I have.
Have you discussed this plea agreement with your lawyer?
Yes, ma'am, I have.
Did you read and sign the agreement?
Yes, ma'am, I did.
Is this your signature at the bottom of the 3rd page?
Yes, ma'am, it is.
Do you understand the rights that you give up when you enter a plea?
Yes, ma'am, I do.
Are you entering the plea freely and voluntarily?
Absolutely, yes, ma'am.
Is anybody forcing you or threatening you?
No, ma'am.
Has anybody promised you anything other than what is showing on this agreement?
No, ma'am.
Are you satisfied with the services of your lawyer?
Yes, I am. Yes, absolutely.
Have you had any drugs, alcohol, medicine, or any type of substance in the last 24 hours?
No, ma'am, I have not.
The score sheet is going to be provided in a little while. Mr. Harper, have you had a chance to review the score sheet?
The state did send it to me by email, and it confirms what my understanding of her history is.
Yes.
All right. And it's...
And she does not score out.
All right. Is there any exculpatory DNA?
Not to my...
I do find
Well,
a...
she has it here.
Oh, there's the score sheet. Fantastic. Thank you. Thank you so much. I have a score sheet. It does show 39.2 total sentence points. Any objections or corrections?
No, Your Honor.
All right. I'm signing the score sheet. I do find a sufficient factual basis based on my review of the arrest report. And ma'am, do you understand that if you're not a citizen, you could be deported?
Yes, ma'am, I do.
All right. And how do you plead to counts 1 and 2?
No contest. Yes.
I accept your plea. I find it was freely and voluntarily entered. In accordance with your agreement, there will be an adjudication of guilt on both counts. On count 1, you'll be placed on probation for 3 years. And you may have contact with the victim. Do I need the initials of the victim?
They are MLR.
Okay. The victim MLR, as allowed by the Georgia Juvenile Court of Richmond County in case number 22. I think that's RCJP 24. Is that right? Okay. Which allows for supervised contact as allowed by the father. So if there's a modification in that case, then whatever the current order in that particular case is regarding contact, that is what this court would, or your probation would align itself with that order.
Okay.
So if there's a change, you need to provide the order to probation, so they know, okay?
Yes, ma'am, thank you.
Sure. Let's see, there's $515 in court costs. Let me make sure that's. Oh, there's an extra $151.
Okay, yes,
court
ma'am.
cost. Okay, so it's 515 plus 151. I'm writing that on here. Plus $150 cost of defense. And then as to count 2, that's the paraphernalia charge, probation will be 11 months and 29 days concurrent to count 1. Did I cover everything, Mr. Harper?
Yes, ma'am.
All right. And ma'am, you will have 30 days to appeal the order of the court. If you can't afford a lawyer, I'll appoint one for you. See Officer Howell before you leave the courtroom. She's sitting right there.
Okay, yes, ma'am.
And then when you leave court, go straight to probation today.
Okay, yes, ma'am.
Good luck, ma'am. Thank you.
Thank you, Mr. Harper. You've been such a help. Thank you.
The next case, Judge, is Stuart Jung, 26 CF 37.
Was she adjudicated guilty or?
Yes, adjudicated guilty on both counts. Okay, and Mr. Harper, you said Stuart
Jung.
Jung, all right, and he is
26
present.
CF 37.
26 CF 37.
Your Honor, at this time, Mr. Jung is going to withdraw his previously entered plea and enter a plea of no contest. This is a withhold of adjudication. Be placed on 2 years of probation to run concurrent. Be assessed $615 in court costs, $150 cost of defense, attend and complete a substance abuse evaluation and any recommended treatment. Eval within 30 days, treatment within 60, 50 hours of community service work, maintain employment or 2 job applications per week. And I'm just writing counts 2 and 3.
So on count 1, it would be 2 years, and then on counts 2 and 3?
11 months and 29 days of probation to run concurrent.
Okay.
I'm just finishing that in here. Okay?
Yes, that's fine.
Your Honor, if I may approach.
Yes, thank you. Thank you so much. Are the court costs $615? All right, sir, if you'll please raise your right hand. Do you swear or affirm the testimony you're about to give will be the truth? If so, say I do.
I do.
Thank you, sir. You can put your hand down. If you'll state your name, please.
Stuart Jung.
Thank you. You're here in 26 CF 37, and you're charged with 1 count of possession of a controlled substance. That's a 3rd-degree felony with a maximum penalty of up to 5 years in prison. 1 count of possession of drug paraphernalia, which is a 1st-degree misdemeanor with a maximum penalty of up to a year in jail. And 1 count of resisting arrest without violence, which is also a 1st-degree misdemeanor with a maximum penalty of up to 1 year in jail. Have you had a chance to talk to your lawyer about those charges and any possible defenses?
Yes, ma'am.
Have you discussed the plea agreement with your lawyer?
Yes, ma'am.
Did you read and sign the agreement?
Yes, ma'am.
Is that your signature
Yes,
at the
ma'am.
bottom of the 3rd page?
Yes, ma'am.
Do you understand the rights that you give up when you enter a plea?
Yes, ma'am.
Are you entering the plea freely and voluntarily?
Yes, ma'am.
Is anybody forcing you or threatening you?
No, ma'am.
Has anybody promised you anything other than what's showing on the agreement?
No, ma'am.
Are you satisfied with the services of your lawyer?
Yes, ma'am.
Have you had any drugs, alcohol, medicine, any type of substance in the last 24 hours?
No, ma'am.
I have a score sheet that shows 16.8 total sentence points. Any objection?
No, Your Honor.
Is there any exculpatory DNA?
Not to my knowledge.
All right. I do find a sufficient factual basis based on my review of the arrest report. And sir, if you're not a U.S. citizen, do you understand you could be deported?
Yes, ma'am.
All right. And how do you plead to counts 1, 2, and 3?
No contest.
I accept your plea. I find it was freely and voluntarily entered. I do have a question. Is it a withhold on all 3 counts?
That was my understanding.
Yes, Your Honor, there's no prior criminal history.
Okay. So in accordance with the agreement, there will be a withhold of adjudication of guilt on all 3 counts. As to count 1, you'll be placed on probation for 2 years, and you'll have to do a substance abuse evaluation within 30 days, and you'll have to start any recommended treatment within 60 days. You'll have to do 50 hours of community service. You'll have to maintain gainful employment or complete 2 job applications per week. And then, of course, all the standard terms and conditions of probation will apply. There will be $615 in court costs, $150 cost of defense. That includes the application fee. And as to counts 2 and 3, all of the counts will be concurrent. And on counts 2 and 3, it'll be 11 months and 29 days of probation on each of those counts. Again, all counts are concurrent, meaning running at the same time. You'll have the full 2 years of probation on count 1 to complete your community service and pay off all your fees and costs and all that. So, did I cover everything, Mr. Harper?
Yes, ma'am.
Yes, Judge.
All right. So, sir, you'll have 30 days to appeal the order of the court. If you can't afford a lawyer, I'll appoint one for you. Good luck to you. See Officer Howell. She's sitting on the front row right over there.
Yes, ma'am.
See her before you leave the courtroom, and then when you leave court, go straight to probation to check in today. All right. Good luck, sir. Thank you.
The next case I have, Judge, is Kayla Raymond.
All right. That is 25 CF 172.
Judge, I've called for Ms. Raymond previously. She is not. What I will say about Ms. Raymond, Judge, is at the last court date, she was actually in the hospital giving birth, which is the reason why she was not present last time.
Okay. So,
I don't know why she's not present today. If the court would permit, in that she just gave birth, if we can move this to 4/20, just to give me one last chance to get a hold of her, see if she can show up. It had been our intention before she gave birth that she was going to plead to the 2-year probation offer.
what I'm going to do, let me sound the courtroom. Kayla Raymond, are you present? Not present. So this is also a situation where Ms. Raymond, I believe, was in failure to appear status for a period of about 6 months. Looks like she failed to appear on June 16th. I issued a capias. She wasn't arrested until December. And now here we are again. So what I'm going to do is issue a capias today. She's got an ROR bond. Bond to be set at first appearance. Actually, you know what? I'm not going to do that because I don't want it to be another ROR. Bond will be $4,000, cash or professional. I will go ahead and set the case for Monday, April 20th. If she appears, not prejudging anything, there's a possibility the capias would be withdrawn if she's present here on time on Monday. So I'll set the case for April 20th at 9 o'clock, docket day. Otherwise, that capias will just be out there.
Yes, ma'am.
But it's being issued now with a bond of $4,000 cash or professional.
The next case I have, Judge, is Carrie Walker, 24 CF 1089.
Okay?
Ms. Walker is present. Your Honor, can we approach on Ms. Walker's case?
Yes. All right, so Ms. Walker is present, case number 24 CF1089. We are setting the case for docket day, that's April 20th at 9 o'clock. And I'll put it down for plea or trial? Okay.
Thank you.
Thank you, ma'am. All right.
And Your Honor, if I can cover one case for Ms. Jaquith.
Yes.
Number 77, Jeremy Eschman. I think there might be a waiver in his case.
There is.
There was a conflict between myself and Mr. Eschman, and so Ms. Jaquith is handling his case. There are depositions in this matter set for May the 20th. I'd ask for a full cycle continuance.
Any objection?
Eschman.
No objection, Your Honor. I did speak with Mr. Jacob about this.
I do see that RCC was just appointed in February, and I saw that the depositions were scheduled for May 20th. So June 8th at 9 o'clock, pretrial conference in Mr. Jeremy Eschman, 25 CF 1944. All right.
Thank you, Judge. That's all I have this morning.
Thank you. And has Mr. Madden shown up? I had a couple of cases on the docket for Mr. Madden. Let's see, let me call the first one. That is 25 CF 1561, Rosario Bernardo Vasquez. And a written plea agreement was submitted and signed on March 18th, so that case just needs to be closed. And then I have another one for Mr. Madden. Cody Hall, 25 CF 1903. Does the state have any, know any? The case was still active when I reviewed the docket, but I don't see Mr. Madden here. Let me check the case.
Yes, Your Honor, this case is still active. We are close to an agreement in this case.
Not sure why Mr. Madden isn't here. I see.
I am just sending him a message to see if there is a conflict. I did have his number, so if the court would like, I can update you when he responds.
Yes, thank you. All right, I'm going to take two cases, and then we will likely be, it's after our lunch hour right now, but the two cases I'm going to take, first of all, Mr. Brian Howard, are you present?
Yes, ma'am.
All right. All right, this is case number 22, CF 2185. And Mr. Howard, if you'll just give me a second to get to your case.
This one's been going on for a while.
Yes, yes, sir. And I don't mean to laugh like that's funny. I mean, yes, you're right. So you had filed a motion to dismiss. I struck it because according to the court record, you're still represented by counsel.
Correct.
Then you filed your motion for reconsideration.
And we still have not heard anything back from the one that Bradley filed with Judge Stone, the motion
Okay.
to dismiss.
Okay. And then when you filed your motion for reconsideration, you attached an order to it that confirmed, which I was not aware of that order being entered until you filed
Yes,
a
ma'am.
copy of it.
Yes, ma'am.
That you are in fact pro se.
Yes, ma'am.
So let me ask, has Judge Stone, did he go through the Ferretta inquiry with you?
All I know is I got an email that he pulled himself off the case after he allowed Brad to quit.
Well, I'm just wondering, did Judge Stone ask you a series of questions about representing yourself?
Yes, ma'am.
All
Yes,
the
ma'am.
risks
Yes,
and
ma'am.
dangers and disadvantages?
Yes, ma'am.
Okay. Do you understand you have the right to be represented by an attorney?
Not in Okaloosa County, I can't.
Okay.
I've already been through every attorney here. Nobody will represent me. I had a court-appointed attorney on a Thursday a couple months ago, and as soon as I walked in, he told me to get out of his office. So we just need to get this thing into trial.
Okay. So the court appointed an attorney for you in this case previously?
Yes, ma'am.
Okay, let me take a look, because I didn't see that.
It was the day that Brad quit, one of the court-appointed attorneys stood up and asked if he could meet up with me on that Thursday.
Has the office of the public defender been previously appointed for you?
No, I don't qualify.
Okay. Do you want to fill out an application and see if you qualify?
I'd rather get this thing to trial and just get it done.
Okay.
It's drug out for 4 years. I haven't seen my kids for 4 years for all these lies. It's time to get it on.
Okay. So, have you ever filled out an application for the public defender's office?
I don't think so.
Okay, you sure you don't want to try it and see if you qualify for a lawyer?
It'll just prolong it even longer. It's time to get it on.
Would you like me to appoint standby counsel for you?
Meaning,
Like a backup attorney, if you decide not to proceed pro se, if you, in the middle of the trial, for whatever reason, if you cannot continue or decide not to continue pro se, I'd have an attorney available as backup.
if he could speak, I don't speak y'all's language. I'm a construction worker. It's like me giving you a hammer and telling you to build a house. It's just not going to happen. But the thing is, I live this case. This case has been going on for 4 years.
Okay.
I've watched pedophile after pedophile walk by and still go home to his kids. I'm done. I'm ready for this thing to get over with.
Would you like me to appoint standby counsel for you?
That's fine.
Okay. I'm appointing the office of the public defender as standby counsel.
He's not going to prolong any of this, correct?
No, sir,
Okay.
that's just if,
Okay.
for whatever reason, you're unable to continue with the trial, or you decide you would like the services of the public defender, they will jump in immediately and take over.
Okay.
So, for instance, and I don't anticipate this applying to you, but I need to give you an example. If we were in the middle of the trial and you became disruptive, and you had to be removed from the courtroom. Again, I'm not saying that's going to happen to you, but I have to give an example.
Right.
Then the standby counsel would swoop in immediately, and we would continue with the trial.
Okay.
And they would take over.
Yes, sure, just so you understand, Mr. Medina has a good understanding of this, but typically, we're here as an encyclopedia. If he has a question like how I do something, that's where we step in and assist. Outside that is all going to be up to Mr. Howard to do everything else.
Yeah, so they're just a backup in case you can't continue or
perfect.
don't want to continue pro se.
That's
I mean, they're
perfect.
not co-counsel with you.
Right.
All right,
Okay.
so they're not going to say anything. They're just going to be a warm body sitting at the desk unless you choose not to proceed pro se or can't.
Just as an officer of the court, I just wanted for the record for him to know, because he may not know what the thresholds are, but basically it's about a $30,000. It's 2 times the poverty rate, which I think is around 30,000 or something. So unless you're making like 40,000 plus.
I make a fortune.
Okay, well, never mind. Thank you.
No attorney will represent me. Ever since Brad gave me that letter, I even had one down in Steenhatchee where I'm from. He's actually suing FDLE. He went to prison, got his stuff overturned. I went back to his office with that letter, and he won't even open up the door for me. It's like I've been boycotted, so.
Okay. Mr. Medina, Mr. Gates, and Mr. Koch, am I able to appoint the PD as standby counsel, or do you need an application filled out?
Mr. Medina, we were just having a conversation.
We've had this come up recently internally, have that discussion. I think basically the court has the prerogative to appoint lawyers to be standby counsel. The problem is if it's the public defender, we cannot swoop in and take the case in an active role. We can be there to advise as standby counsel on matters of courtroom decorum, for instance. But it's not a full-blown standby availability if it's the PD, as
Okay.
far as I know.
I'll follow Mr. Medina, he's had this issue come up more than I have.
I know that I'm 143 grand into this case, so I mean, it's not it's like I said, it's time for it to put it to bed.
So in the other case, Mr. Medina, that you had in a similar situation, what were the options?
Well, basically, it's one that the court can appoint the public defender to be the standby counsel, but the public defender would not be able to provide the active counsel role in the event that the gentleman, after having Ferretta instructions, decides he wants an active counsel because he's not eligible.
Okay. Thank you.
And there's also, we've been sending papers in to try to get evidence, and nobody's responding to our evidence.
Okay, I don't know what that means, but
Your
Ms.
Honor,
Herman
Ashley
is...
Herndon for the state. There have been 3 motions that were filed since 12 a.m. this morning. We have been providing discovery to the email address of record. Some of the links have not been opened or downloaded.
Yes, that's the problem. I'm not technically inclined when it comes to this thing.
So, Your Honor, I think Ferretta does need to be done. I am not sure that it's clear based on what's in the clerk of court's records that Ferretta has been read by Judge Stone. We have a trail. We have responded to everything that's been requested. And what our links show is that they have not been downloaded and opened. But there were a number of motions that were filed since midnight today, one of which is a 17-person witness list by the defendant. 9 of the witnesses are not witnesses listed by the state. So based upon that, one of them is the former judge on the case, Judge Stone. So I am assuming that if he is in fact subpoenaed, there are matters that would have to be handled administratively regarding that. The former attorney for the defendant is also listed on the witness list. So based on that, the state probably is going to need to respond. I don't know if Mr. Howard wants to go on and send subpoenas because that is going to effectuate a whole nother list of procedures that would be done based upon the subpoenaing of a judge that was formerly assigned to the case. But I don't see, based on at least that filing, that the case would be able to proceed to trial this cycle.
How would we send a subpoena if we don't have a trial date?
Judge, I am not at liberty to give Mr. Howard legal advice.
I am looking, I see things that were filed today. Sir, I do need to, let me look at one other thing. I don't see where a full Ferretta inquiry was done. That is a series of questions, probably a 30-minute hearing, where the court has to ask you and advise you about all the dangers and disadvantages of representing yourself and advise you of your rights.
Mm-hmm.
I don't see in the record where that has been done.
But Judge Stone did that on the September, or no, the 11th, the November case.
November
No.
10th?
It was the
I'm not-
September one then.
Okay, I think there's somebody talking.
Yeah, she's with me.
Okay. I'm looking at the notes or the clerk's minutes from November 10th, and it just says defendant will hire new counsel. That's what
Correct.
the notes say.
That's when I thought that I had the one down in Steenahatchee that was gonna come.
I'm going to need to schedule a Ferretta hearing, so let's go ahead and get that figured out when we're going to.
Can we do it soon?
Yes, I'm
Okay.
working on that. Let me
Okay.
get you a date. And I did see your witness list that you filed.
Yeah, I've got, the witness list is crazy. I got one that's pregnant, she's,
Well, I'm just, there are some,
big boys on there.
well, I mean, if you're planning to subpoena Judge Stone
Yes,
to
ma'am.
testify in your trial, that
Yes,
is going to
ma'am.
set off a chain of events that we probably have to have hearings on that.
Just make sure that
So-
you know Brian Howard was the one that did it.
So let me find you a date.
January 12th. January 12th is when Judge Stone went over.
There's someone speaking
Yeah,
from the
she's saying
audience
that-
that the court reporter I know will not be able to hear.
She's saying that January 12th was the date that Judge Stone went over the inquiry with me.
Okay, well,
And he may not have, nobody, because a lot of the times he was pushing his mic to the side every time he talked to me.
let me find you a date because I need to do the
Yes,
inquiry
ma'am.
with you.
Yes, ma'am.
We could do April 21st.
That's fine.
That's next Tuesday.
I will be here.
All right, just one second. Let me go through and see if there's anything else we need to cover. That's April 21st, 9 o'clock for Ferretta. And then you've got other motions filed. Let's see what we need to do about those. There's a motion to compel that was filed this morning. Is the state going to be in a position to proceed with a hearing on that?
Your Honor, we are not. Our witnesses are from FDLE. One of the FDLE agents has been reassigned to the governor's cabinet in Tallahassee. I will need longer than a week to have him in court. If it would be possible to set that for the court's next miscellaneous day, so that we can get through Ferretta first, depending on the ruling there.
Okay.
If we could have some time after that.
Okay. Now, there is also, let me just get to this first. You asked for reconsideration of your motion to dismiss. Sir, you had cited fake cases in your motion to dismiss, so I struck it on the grounds of, at that time,
Right,
according to the record.
Yeah, that was that AI stuff,
Yeah.
yes.
Yeah, it's going to be stricken for that basis. If not, I mean, I struck it because it appeared from the court record you were still represented by counsel, but I
Right.
pointed out the fake case law in there. That's an independent basis to strike it. I'm not going to consider anything with fake case law.
Yes, I understand.
So let's set the Ferretta hearing April 21st at 9. And then, Ms. Herndon, how far out do you need for the other motions?
Your Honor, if we could have 3 weeks potentially for the motion to compel. Some of the information, as I said, has been provided. I have not gone through the one from today. I just glanced through that regarding Facebook records, but I'm going to need to have the FDLE witnesses here for that.
Okay, so how about the morning of May 14th?
Yes, Your Honor, that should work.
And I need to be here May 14th too?
Yes, so that's May 14th, 9 o'clock. And that will be your motion to compel see. You've got a motion to take judicial notice. That was filed on April 7th. You've got a notice that was filed last night after, well, around midnight. Notice regarding material witness and missing discovery. Whatever that is about, we will handle that on May 14th as well. That's docket number 260. Docket 257 is the one for judicial notice. So if you want other things to be heard, we got to get through the Ferretta hearing
Yes,
next
ma'am.
week first.
Yes, ma'am.
If you want other things to be heard on May 14th, you've got to file them in
And-
enough
yes,
time.
yes, ma'am.
So that the state can review it and be prepared, and if
And I
they
know
have to
that
have
they're-
witnesses, they
yes,
have to
ma'am.
have time.
I know that there are a couple other things that we're planning, so,
Okay?
so we'll know everything April 21st?
April 21st, that's next Tuesday at
Okay.
9 o'clock. Now, I say 9 o'clock, everything's set for 9 o'clock. It's going to be a long day.
Yes, ma'am.
So you're going
Yes,
to be
ma'am.
with me for a long time.
Yes, ma'am.
That's at least about a 30-minute hearing.
Okay,
So, you know, I'm just warning you, it's going to be a long day.
okay, thank you very much.
Sure, I'll see you on April 21st, and we're going to go ahead and set one other court date as well, since you're here. Let's set June 8th as pretrial conference at 9 o'clock. So right now, you have 3 court dates set. April 21st, that's next Tuesday, 9 o'clock. Well, whenever we can get to you during that day, but we're starting court at 9. Then I've got May 14th at 9, that's your motion day, depending on the outcome of how April 21st goes. And then we've got your next pretrial of June 8th at 9.
And then the pretrial on June 8th, that's going to pretty much say that this is going to be our go date.
That is the day that, assuming all motions are resolved and your attorney's situation or
Right.
lack thereof is resolved, then what we would be doing is
Setting
planning for trial,
Okay.
yes.
Okay.
So trial, if we go that time, it'll be either the week of June 22nd or July 6th.
Okay.
Those are the trial dates. All
Okay,
right?
thank you very
I'll
much.
see you next Tuesday, sir. Thank you. All right, and I have one more case that I need to take before lunch, and that's Mr. John Mendez Hurlbert, case 26 CF 91. Mr. John Mendez Hurlbert, are you present? 26 CF 91. All right. Thank you, sir. And defendant is present. And I have Mr. Gates present as standby counsel. All right, we're here for pretrial conference.
Is this a court of records?
Sorry?
Is this a court of records?
I'm not sure what you mean by that, sir.
Is this on the record?
All court proceedings in criminal court are recorded, yes, sir.
Okay.
All right, so,
Great. I'd like to say that I'm in holistic, organic, living man of the land, of my ancestors. I preserve all rights, waive none. I'm here by special appearance. Let's see here. I got notes and stuff, so.
okay.
I am the director, I'm the executive director and president beneficiary of the registered agent of the estate. I hold up my birth certificate, surrendering the birth certificate to the court to confirm, to the court, not to be confused with the all caps entity created by assumed name on the driver's license. I hereby come in peace. I withdraw from the War Powers Acts of the Trading with the Enemy Acts of 1917. I refuse, I release myself and I release myself as the surety and due just compensation refund to me as this is a financial matter. Then the living indigenous man is me and who they must pay up to. Okay. I do not consent to these proceedings. I peacefully withdraw from all legal fiction, corporate, person responsibilities. I'm only here to settle this matter as an executor, and again, I do not consent to these proceedings. I have no contract or charging papers. I have not seen bookkeepings or accounts or notified the IRS that money is being created in the all caps assumed name. Security bonds, taxes are due according to my counsel, which is the Most High.
Thank you.
I do not consent. There is no contract. This is a tax court. Everything previous to what's been said before has been null and void because failure to show the contracts. There is no injured party in this case. If there is an injured party, for the record, please have them stand, and it must be a living man or woman. I do not consent, I do not comprehend. UCC 1308, 207, all rights reserved, Public Law 93, 579, without prejudice. And I invoke the Brady Law, which means everything within this case has to be presented. And again, here is the birth certificate, I surrender it. This takes care of all the taxes that this case has created under my name.
All right, I'm not sure what you mean by that, Mr., is it Mendez Hurlbert or just Hurlbert? Or is it Mendez? I just want to get your name right, I'm sorry.
It's neither.
Okay, what is your name?
My living name is John Felix Mendez Herbert. I am the living man on the soil.
All right, so, sir, I'm not sure what
I've also
all of
sent,
that means.
I've also sent in all this documentation for you to view as of Friday. Haven't heard anything. I didn't see my name on the paperwork outside. If I wasn't standing here, I wouldn't know I was supposed to be here.
Okay, I cannot read emails from litigants, so anything you want the court to consider has to be filed in the court file. If you want a motion to be heard, you have to file it in the court file and then contact the clerk to get a hearing date on that. But I cannot read or respond to emails from parties. So, I know you've been sending emails. Those go straight to the IT department. I have not read anything that you have sent, sir. I'm not able to do that.
UCC 1-13-103-103.6.
Okay.
Just making sure that everything that I need to say was on the record
All right.
for public consumption.
Thank you. So,
And I'm not the fictitious person on this document. I'm the living man.
all right. Well, so you understand about the emails, right?
I do not consent. I do not comprehend.
You don't understand that I can't read your emails?
I do not comprehend.
Okay, now I'm concerned, I'm getting some different concerns. You're not understanding what I'm saying?
I do not consent to what you're saying.
Okay,
I do not
I'm telling
comprehend.
you that I cannot read your emails.
You've already read my emails.
No,
We have
sir.
evidence you did.
No, sir.
Somebody with your email access viewed an
Those were
email.
forwarded straight to IT.
Okay.
Yes, they were sent straight to IT. I can't have emails from parties, sir. Anything that you want the court to consider has to be filed in the court file. If it's
Okay,
a
well,
motion.
I still have more stuff to present then.
Your Honor, the state is ready for trial.
Okay.
First thing. Second thing, it is my understanding that the victims in this case are receiving hundreds of pages of faxes from the defendant. They're in their 80s. Apparently, they still have a fax machine. They're receiving hundreds of pages of faxes from Mr. Holbert. I would ask, I know that you've already advised Mr. Holbert of this during his Ferretti hearing, but I would ask that you remind Mr. Holbert as to what he can and cannot do with respect to contact with the victims in this case. But as far as if there are additional issues that Mr. Holbert has for this court, we would ask that he file a motion, that he set a hearing, but that this is not the appropriate place for us.
Objection, Your Honor. I'd like to see the report that the victims are injured parties. Is there a medical report? Is
Your Honor,
there,
all I've asked-
where's the evidence?
all I've asked
I just want to know where the evidence is at.
Mr. Holbert, of what he can and can't do with respect to contact with victims and witnesses in this case. I have not filed a motion for protective order. I'm not seeking any other relief than to remind Mr. Holbert as to what he can and can't do with respect to contact of victims and witnesses as a pro se.
So
Your Honor, I still need to see the victims. He cannot be the victim and the lawyer at the same time.
Okay, so I am looking at the bond conditions.
Where's the injured party? That's what I want to know.
Sir, just one second. I'm trying to address what Mr. Ferris was
What
saying.
jurisdiction is this? Sorry, I just need to understand.
Sir,
I'm trying to
just bear
understand.
with me for a minute, okay?
Okay.
Mr. Ferris, I'm looking at the bond conditions. I don't see restrictions on it.
Your Honor, with respect to contact, not with respect to bond, but with respect to that Ferretti hearing, Mr. Holbert was advised as to what he can and can't do with respect to direct contact of victims and witnesses. He is sending hundreds of pages of faxes to the victims.
You'll
We
need
are
to file a motion.
we are suing them. That's what's happening. All this is fictitious. We're suing them.
You'll need to file a motion. Mr. Hurlbert, are you ready for trial? Today is, you got a few options.
I just received more information from them.
Okay.
So that I need to review all of it, and then I need to submit more paperwork, because this is obviously a tax court, and I surrendered my birth certificate to pay for it. Maybe you're not aware of it, but there's many people that are aware of what's happening here.
All right, well.
Just for the record, Your Honor, he did file a notice of discovery on Friday. And
Oh,
we have-
okay.
We have provided discovery today.
Okay, so the state has provided you with discovery. In fact, I'm looking at it. It was filed today, this morning.
There was an amended, Your Honor, there was an amended exhibit this morning that identified some additional witnesses. We actually filed it back in February and attempted to contact Mr. Holbert as to how he would like to receive it. Before we received the notice of discovery, we have now received the notice of discovery. Mr. Holbert indicating that he's willing.
I did not consent. I did not consent.
Discovery, we have now served, he has received the discovery that he requested on Friday today.
So this morning, it looks
Who is,
like.
what jurisdiction are we under? Because I need to understand.
This is the
this
circuit
amity law?
court.
Because there's no contract? Is this regular
This-
law? There's no
sir.
injured party? I need to know all these things so that I
Sir.
can prepare correctly.
This is the circuit court in and for Okaloosa County, Florida. I'm looking at the discovery, amended discovery exhibit that was filed by the state this morning, and it looks like, Mr. Ferris, it says on here, please provide a thumb drive if checked, and it looks like the box is checked. Are you needing Mr. Hurlbert to provide you with a thumb drive for the discovery?
As I understand it, how do you want to receive discovery?
Let's see here. How do I want?
You can provide us with a thumb drive, you can provide us with an email.
Well, the email's fine. I'll be emailing you again.
Would that be the King Smarty email address?
That's the boss.
Okay. So.
That's who I am, by the way.
Okay.
King Smart. Not John Felix Mendez on his paperwork.
Okay.
This is fictitious. This is
So-
made up. I'm sure you all know about it.
All right, so let's see. I don't know if you have motions that you wish to have heard, but I can't hear them today. You would need to contact the clerk for a court date unless you want me to set one right now.
The day I saw you, you said that you just received it and you didn't have time to look at it. I
Okay.
move for this to be dismissed. There's no injured party. There's no jurisdiction. And this is a waste of my time, and I will be seeking financial, what do you call it, compensation for all this.
All right. So I do see your motion to dismiss.
Yes, ma'am. I've been trying to tell everyone that I'm not guilty of any of this stuff, and there's no evidence to prove so.
When would you like to set that? State? I've got, and Mr. Herbert, I've got next Tuesday. Is that too soon for this?
That's too soon for subpoenas, Your Honor.
Okay. Then we have May 19th. We have the morning of May 14th.
Either of those dates is not with the state, Your Honor.
And can you have him supply me with everything I just requested?
What all did you just request?
Jurisdiction, the injured party, the medical records that there was an injured party, and everything else that I said. We can go back and rewatch these videos. I did say I invoked the Brady Act, right? Because everything that has to do with this case, including the taxes and banking, all of it has to be put on the table.
May 14th. At 9 o'clock?
And that's on the defendant's motion to dismiss, correct, Your Honor?
Yes. Now, sir, if you have other motions that you want to have heard, you need to file them, I would say, how long do you
I
need to get?
request this to be dismissed.
Yes, we've got that scheduled for May 14th at 9. You'll have a hearing. So I'm wondering if you have other motions that we also need to hear.
No, I'm asking you,
Okay.
I'm accepting your oath of office to do in the interest of justice, to dismiss this case based on there's no evidence. There's no injured party. There's no jurisdiction.
We're going to hear your motion to dismiss on May 14th.
What's wrong with hearing me right now?
Today is not a motion day.
Okay.
So May 14th at 9 is your motion to dismiss. Now, if you have other motions that you'd like to have heard on that day, you need to file them in sufficient time so that the state can review them in time to be prepared, and if they need to
Okay,
subpoena
now-
people,
Okay.
they need to have time. So how much lead time do you need, Mr. Ferris? If other motions are filed,
Can
how
I-
much
can I hand this to him?
advance
If it's
time?
an evidentiary hearing, then we need to deal with
Like
subpoenas.
2 weeks or what?
2 weeks.
Okay, so really by May 1st, anything else you want to be heard on May 14th, you need to file it by May 1st, and then contact the clerk to let him know that you want to add that to the hearing.
Okay, well, like I said, I don't
Actually, I think
consent.
on May 14th, you would contact,
Well, like I said, I don't consent to any of this stuff, and that should be efficient. Here's my birth certificate. I'll leave it here.
if you leave that there, it's going to remain there.
It's all right.
The court's
It's on
not
the
taking
record that it
possession of
was
that.
submitted. It was,
It's going to remain right there on that podium, sir.
okay.
I mean, that's,
I surrendered
That's
my
not
birth
filing.
certificate.
That's not
That's what's
filing.
bringing everybody into court, their birth certificates, so I surrendered mine here.
all right. Well, I recommend you don't leave your birth certificate up there for anything to happen to it, because that's not filed with the court, left there on the podium, sir.
It's okay, it is record, and the man upstairs is watching, so it's
All
here.
right.
Have a great day.
May 14th at 9, and we need to set another court date, sir. June 8th. Pretrial conference at 9.
I do not
Your Honor,
consent.
the state would ask that that be the last continuance, that this be the last continuance, and that we proceed to trial immediately after the June.
I do not consent.
Okay.
I do not comprehend.
Well, I'm setting June 8th at 9 is also a court date for you. That's pretrial conference. So you have 2 right now, May 14th and June 8th.
Are
All
you
right.
attempting to administer my trust without my consent?
I don't know what you're saying, sir, but I will see you on May 14th
Okay.
at 9 for your motion to dismiss.
Okay.
Thank you, sir. Good luck to you. All right, so I see Mr. Madden, and Mr. Madden, we're going to have to take your case quickly because it is well past lunch.
Thank you, Your Honor. And I apologize, Your Honor, there was it's just a miswritten down on my calendar, but I take full responsibility of that, and I apologize to the court. I'm here on behalf of Cody Hall. We have received a plea agreement to, I believe, should resolve all his cases. I just need an opportunity to talk to him about it, so we can just leave this set on the current cycle without subpoenas, and I believe the case should be concluded.
Okay, so this is 25 CF 1903 Cody Hall, and we will set the case for April 20th. That's next Monday, docket day, and I'll just put plea or hopeful plea or continue.
That is my plan, Your Honor.
Okay.
Thank you very much, Your Honor. I'm sorry again.
Thank you. All right, so we need to take a lunch break. It's overdue. So we are going to be in recess until 1:45. That's just shy of an hour. 1:45. Thank you.